Chapter 16, paragraph 2, part B, of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Anna Simon. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16, Division of Offences, paragraph 2. Divisions and Subdivisions, Part B. We come now to offences against trust. A trust is, where there is any particular act which one party, in the exercise of some power or some right, which is conferred on him, is bound to perform for the benefit of another. Or, more fully, thus: a party is said to be invested with a trust, when, being invested with a power or with a right, there is a certain behaviour which, in the exercise of that power, or of that right, he is bound to maintain for the benefit of some other party. In such case, the party first mentioned is styled a trustee. For the other party, no name has ever yet been found. For want of a name, there seems to be no other resource than to give a new and more extensive sense to the word beneficiary, or to say at length the party to be benefited. The trustee is also said to have a trust conferred or imposed upon him, to be invested with the trust, to have had a trust given him to execute, to perform, to discharge, or to fulfil. The party to be benefited is said to have a trust established or created in his favour, and so on through a variety of other phrases. Now it may occur that a trust is oftentimes spoken of as a species of condition, that a trust is also spoken of as a species of property, and that a condition itself is also spoken of same light. It may be thought, therefore, that in the first class the division of offences against condition should have been included under that of the offences against property, and that at any rate so much of the fifth class now before us as contains offences against trust should have been included under one or other of those two divisions of the first class. But upon examination it will appear that no one of these divisions could with convenience, nor even perhaps with propriety, have been included under either of the other two. It will appear at the same time that there is an intimate connection subsisting amongst them all, insomuch that of the lists of the offences to which they are respectively exposed, any one may serve in great measure as a model for any other. There are certain offences to which all trusts as such are exposed. To all these offences every sort of condition will be found exposed, at the same time that particular species of the offences against trust will, upon their application to particular conditions, receive different particular denominations. It will appear also that of the two groups of offences into which the list of those against trust will be found naturally to divide itself, there is one, and but one, to which property, taken in its proper and more confined sense, stands exposed, and that these, in their application to the subject of property, will be found susceptible of distinct modifications, to which the usage of language and the occasion there is for distinguishing them in point of treatment make it necessary to find names. In the first place, as there are, or at least may be, as we shall see, conditions which are not trusts, so there are trusts of which the idea would not be readily and naturally understood to be included under the word condition. Add to which that of those conditions which do include a trust, the greater number include other ingredients along with it, so that the idea of a condition, if on the one hand it stretches beyond the idea of a trust, does on the other hand fall short of it. Of the several sorts of trusts, by far the most important are those in which it is the public that stands in the relation of beneficiary. Now these trusts, it should seem, would hardly present themselves at first view upon the mention of the word condition. At any rate, what is more material, the most important of the offences against these kinds of trust would not seem to be included under the denomination of offences against condition. The offences which by this latter appellation would be brought to view would be such only as seem to affect the interests of an individual, of him, for example, who is considered as being invested with that condition. But in offences against public trust, it is the influence they have on the interests of the public that constitutes by much the most material part of their pernicious tendency; the influence they have on the interests of any individual, the only part of their influence which would be readily brought to view by the appellation of offences against condition, is comparatively as nothing. The word trust directs the attention at once to the interests of that party for whom the person in question is trustee; which party, upon the addition of the epithet public, is immediately understood to be the body composed of the whole assemblage, or an indefinite portion of the whole assemblage of the members of the State. The idea presented by the words public trust is clear and unambiguous. It is but an obscure and ambiguous garb that idea could be expressed in by the words public condition. It appears, therefore, that the principal part of the offences included under the denomination of offences against trust could not, commodiously at least, have been included under the head of offences against condition. It is evident enough that for the same reasons neither could they have been included under the head of offences against property. It would have appeared preposterous, and would have argued a total inattention to the leading principle of the whole work, the principle of utility, to have taken the most mischievous and alarming part of the offences to which the public stands exposed, and forced them into the list of offences against the property of an individual, of that individual, to wit, who in that case would be considered as having in him the property of that public trust which by the offences in question is affected. Nor would it have been less improper to have included conditions, all of them, under the head of property, and thereby the whole catalogue of offences against condition under the catalogue of offences against property. True it is that there are offences against condition which, perhaps with equal propriety and without any change in their nature, might be considered in the light of offences against property. So extensive and so vague are the ideas that are wont to be annexed to both these objects. But there are other offences which, though with unquestionable propriety they might be referred to the head of offences against condition, could not, without the utmost violence done to language, be forced under the appellation of offences against property. Property, considered with respect to the proprietor, implies invariably a benefit, and nothing else. Whatever obligations or burthens may by accident stand annexed to it, yet in itself it can never be otherwise than beneficial. On the part of the proprietor it is created not by any commands that are laid on him, but by his being left free to do with such or such an article as he likes. The obligations it is created by are in every instance laid upon other people. On the other hand, as to conditions, there are several which are of a mixed nature, importing, as well as a burden to him who stands invested with them, as a benefit, which indeed is the case with those conditions which we hear most of under that name, and which make the greatest figure. There are even conditions which import nothing but burden, without any spark of benefit. Accordingly, when between two parties there is such a relation that one of them stands in the place of an object of property with respect to the other, the word property is applied only on one side, but the word condition is applied alike to both. It is but one of them that is said on that account to be possessed of property, but both of them are alike spoken of as being possessed of or being invested with a condition. It is the master alone that is considered as possessing a property, of which the servant, in virtue of the services he is bound to render, is the object; but the servant, not less than the master, is spoken of as possessing or being invested with a condition. The case is that if a man's condition is ever spoken of as constituting an article of his property, it is in the same loose and indefinite sense of the word in which almost every other offense that could be imagined might be reckoned into the list of offenses against property. If the language indeed were in every instance in which it made use of the phrase object of property, perspicuous enough to point out under that appellation the material and really existent body, the person or the thing in which those acts terminate, by the performance of which the property is said to be enjoyed; if, in short, in the import given to the phrase object of property, it made no other use of it than the putting it to signify what is now called a corporeal object, this difficulty and this confusion would not have occurred. but the import of the phrase object of property, and in consequence the import of the word property, has been made to take a much wider range. In almost every case in which the law does anything for a man's benefit or advantage, men are apt to speak of it on some occasion or other as conferring on him a sort of property. At the same time, for one reason or other, it has in several cases been not practicable or not agreeable to bring to view, under the appellation of the object of his property, the thing in which the acts, by the performance of which the property is said to be enjoyed, have their termination, or the person in whom they have their commencement. Yet something which could be spoken of under that appellation was absolutely requisite. The expedient then has been to create, as it were, on every occasion, an ideal being, and to assign to a man this ideal being for the object of his property. And these are the sort of objects to which men of science, in taking a view of the operations of the law in this behalf, came, in process of time, to give the name of incorporeal. Now of this incorporeal object of property the variety is prodigious. Fictitious entities of this kind have been fabricated almost out of everything, not conditions only, that of a trustee included, but even reputation have been of the number. Even liberty has been considered in this same point of view; and though on so many occasions it is contrasted with property, yet on other occasions, being reckoned into the catalogue of possessions, it seems to have been considered as a branch of property. Some of these applications of the words property, object of property, the last for instance, are looked upon, indeed, as more figurative, and less proper than the rest. But since the truth is, that where the immediate object is incorporeal, they are all of them improper, it is scarce practicable anywhere to draw the line. Notwithstanding all this latitude, yet, among the relations in virtue of which you are said to be possessed of a condition, there is one at least which can scarcely, by the most forced construction, be said to render any other man, or any other thing, the object of your property. This is the right of persevering in a certain course of action, for instance in the exercising of a certain trade. Now, to confer on you this right, in a certain degree at least, the law has nothing more to do than barely to abstain from forbidding you to exercise it. Were it to go farther, and, for the sake of enabling you to exercise your trade to the greater advantage, prohibit others from exercising the like, then, indeed, persons might be found who, in a certain sense, and by a construction rather forced than otherwise, might be spoken of as being the objects of your property, that is, by being made to render you that sort of negative service which consists in the forbearing to do those acts which would lessen the profits of your trade. But the ordinary right of exercising any such trade or profession, as is not the object of a monopoly, imports no such thing, and yet by possessing this right a man is said to possess a condition, and by forfeiting it to forfeit his condition. After all, it will be seen that there must be cases in which, according to the usage of language, the same offence may, with more or less appearance of propriety, be referred to the head of offences against condition, or that of offences against property, indifferently. In such cases the following rule may serve for drawing the line. Wherever, in virtue of your possessing a property, or being the object of a property possessed by another, you are characterized, according to the usage of language, by a particular name, such as master, servant, husband, wife, steward, agent, attorney, or the like, there the word condition may be employed in exclusion of the word property, and an offence in which, in virtue of your bearing such relation, you are concerned, either in the capacity of an offender or in that of a party injured, may be referred to the head of offences against condition, and not to that of offences against property. To give an example: being bound, in the capacity of land steward to a certain person, to oversee the repairing of a certain bridge, you forbear to do so. In this case, as the services you are bound to render are of the number of those which give occasion to the party from whom they are due to be spoken of under a certain generical name, viz., that of land steward, the offence of withholding them may be referred to the class of offences against condition. But suppose that, without being engaged in that general and miscellaneous course of service, which with reference to a particular person would denominate you his land steward, You are bound, whether by usage or by contract, to render him that single sort of service which consists in the providing, by yourself or by others, for the repairing of that bridge. In this case, as there is not any such current denomination to which, in virtue of your being bound to render this service, you stand aggregated, for that of architect, mason, or the like is not here in question, the offence you commit by withholding such service cannot with propriety be referred to the class of offences against condition. It can only therefore be referred to the class of offences against property. By way of further distinction, it may be remarked that where a man, in virtue of his being bound to render, or of others being bound to render him, certain services, is spoken of as possessing a condition, the assemblage of services is generally so considerable, in point of duration, as to constitute a course of considerable length, so as on a variety of occasions to come to be varied and repeated; and in most cases, when the condition is not of a domestic nature, sometimes for the benefit of one person, sometimes for that of another. Services which come to be rendered to a particular person on a particular occasion, especially if they be of short duration, have seldom the effect of occasioning either party to be spoken of as being invested with a condition. The particular occasional services which one man may come, by contract or otherwise, to be bound to render to another, are innumerably various; but the number of conditions which have names may be counted, and are comparatively but few. If, after all, notwithstanding the rule here given for separating conditions from articles of property, any object should present itself which should appear to be referable, with equal propriety, to either head, the inconvenience would not be material, since in such cases, as will be seen a little farther on, whichever appellation were adopted, the list of the offences to which the object stands exposed would be substantially the same. These difficulties being cleared up, we now proceed to exhibit an analytical view of the several possible offences against trust. Offences against trust may be distinguished, in the first place, into such as concern the existence of the trust in the hands of such or such a person, and such as concern the exercise of the functions that belong to it. First, then, with regard to such as relate to its existence. An offence of this description, like one of any other description, if an offence it ought to be, must to some person or other import a prejudice. This prejudice may be distinguished into two branches: one, that which may fall on such persons as are or should be invested with the trust; two, that which may fall on the persons for whose sake it is or should be instituted, or on other persons at large. To begin with the former of these branches. Let any trust be conceived. The consequences which it is in the nature of it to be productive of to the possessor must, in as far as they are material, be either of an advantageous or of a disadvantageous nature. In as far as they are advantageous, the trust may be considered as a benefit or privilege; in as far as they are disadvantageous, it may be considered as a burden. To consider it then upon the footing of a benefit. The trust either is of the number of those which ought by law to subsist, that is, which the legislator meant should be established, or is not. If it is, the possession which at any time you may be deprived of with respect to it must at that time be either present or to come. If to come, in which case it may be regarded either as certain or as contingent, the investitive event, or event from whence your possession of it should have taken its commencement, was either an event in the production of which the will of the offender should have been instrumental, or any other event at large. In the former case the offence may be termed wrongful non-investment of trust; in the latter case, wrongful interception of trust. If at the time of the offence whereby you are deprived of it, you were already in possession of it, the offence may be styled wrongful divestment of trust. In any of these cases the effect of the offence is either to put somebody else into the trust or not; if not, it is wrongful divestment, wrongful interception, or wrongful divestment, and nothing more. If it be, the person put in possession is either the wrongdoer himself, in which case it may be styled usurpation of trust, or some other person, in which case it may be styled wrongful investment or attribution of trust. If the trust in question is not of the number of those which ought to subsist, it depends on the manner in which one man deprives another of it, whether such deprivation shall or shall not be an offence, and, accordingly, whether non-investment, interception, or divestment shall or shall not be wrongful. But the putting any body into it must at any rate be an offence, and this offence may be either usurpation or wrongful investment, as before. In the next place, to consider it upon the footing of a burden. In this point of view, if no other interests than that of the persons liable to be invested with it were considered, it is what ought not upon the principle of utility to subsist. If it ought, it can only be for the sake of the persons in whose favour it is established. If then it ought not on any account to subsist, neither non-investment, interception, nor divestment can be wrongful with relation to the persons first mentioned, whatever they may be on any other account, in respect of the manner in which they happen to be performed. For usurpation, though not likely to be committed, there is the same room as before; so likewise is there for wrongful investment, which, in as far as the trust is considered as a burden, may be styled wrongful imposition of trust. If the trust, being still of the burdensome kind, is of the number of those which ought to subsist, any offence that can be committed, with relation to the existence of it, must consist either in causing a person to be in possession of it who ought not to be, or in causing a person not to be in possession of it who ought to be. In the former case it must be either usurpation or wrongful divestment, as before; in the latter case, the person who is caused to be not in possession is either the wrongdoer himself or some other. If the wrongdoer himself, either at the time of the offence he was in possession of it, or he was not. If he was, it may be termed wrongful abdication of trust; if not, wrongful detractation, or non-assumption. If the person whom the offence causes not to be in the trust is any other person, the offence must be either wrongful divestment, wrongful non-investment, or wrongful interception, as before; in any of which cases to consider the trust in the light of a burden, it might also be styled wrongful exemption from trust. Lastly, with regard to the prejudice which the persons for whose benefit the trust is instituted, or any other persons whose interests may come to be affected by its existing or not existing in such or such hands, are liable to sustain. Upon examination it will appear that by every sort of offence whereby the persons who are or should be in possession of it are liable, in that respect, to sustain a prejudice, the persons now in question are also liable to sustain a prejudice. The prejudice in this case is evidently of a very different nature from what it was of in the other, but the same general names will be applicable in this case as in that. If the beneficiaries, or persons whose interests are at stake upon the exercise of the trust, or any of them, are liable to sustain a prejudice resulting from the quality of the person by whom it may be filled, such prejudice must result from the one or the other of two causes: 1. From a person's having the possession of it who ought not to have it; or 2. From a person's not having it who ought. Whether it be a benefit or burden to the possessor is a circumstance that to this purpose makes no difference. In the first of these cases, the offences from which the prejudice takes its rise are those of usurpation of trust, wrongful attribution of trust, and wrongful imposition of trust. In the latter, wrongful non-investment of trust, wrongful interception of trust, wrongful divestment of trust, wrongful abdication of trust, and wrongful detractation of trust. So much for the offences which concern the existence or possession of a trust. Those which concern the exercise of the functions that belong to it may be thus conceived. You are in possession of a trust. The time then for your acting in it must, on any given occasion, neglecting for simplicity's sake the then present instant, be either past or yet to come. If past, your conduct on that occasion must have been either conformable to the purposes for which the trust was instituted, or unconformable. If conformable, there has been no mischief in the case. If unconformable, the fault has been either in yourself alone, or in some other person, or in both. In as far as it has lain in yourself, it has consisted either in your not doing something which you ought to do, in which case it may be styled negative breach of trust, or in your doing something which you ought not to do. If in the doing something which you ought not to do, the party to whom the prejudice has accrued is either the same, for whose benefit the trust was instituted, or some other party at large. In the former of these cases, the offence may be styled positive breach of trust; in the other, abuse of trust. In as far as the fault lies in another person, the offence on his part may be styled disturbance of trust. Supposing the time for your acting in the trust to be yet to come, the effect of any act which tends to render your conduct unconformable to the purposes of the trust may be either to render it actually and eventually unconformable, or to produce a chance of its being so. In the former of these cases it can do no otherwise than take one or other of the shapes that have just been mentioned. In the latter case the blame must lie either in yourself alone, or in some other person, or in both together, as before. If in another person, the acts whereby he may tend to render your conduct unconformable must be exercised either on yourself or on other objects at large. If exercised on yourself, the influence they possess must either be such as operates immediately on your body, or such as operates immediately on your mind. In the latter case, again, the tendency of them must be to deprive you either of the knowledge, or of the power, or of the inclination, which would be necessary to your maintaining such a conduct as shall be conformable to the purposes in question. If they be such of which the tendency is to deprive you of the inclination in question, it must be by applying to your will the force of some seducing motive. Lastly, this motive must be either of the coercive or of the alluring kind. In other words, it must present itself either in the shape of a mischief or of an advantage. Now, in none of all the cases that have been mentioned, except the last, does the offence receive any new denomination. According to the event it is either a disturbance of trust, or an abortive attempt to be guilty of that offence. In this last it is termed bribery, and it is that particular species of it which may be termed active bribery, or bribe-giving. In this case, to consider the matter on your part, either you accept of the bribe or you do not. If not, and you do not afterwards commit, or go about to commit, either a breach or an abuse of trust, there is no offence on your part in the case. If you do accept it, whether you eventually do or do not commit the breach or the abuse which it is the bribe-giver's intention you should commit, you at any rate commit an offence which is also termed bribery, and which, for distinction's sake, may be termed passive bribery, or bribe-taking. As to any farther distinctions, they will depend upon the nature of the particular sort of trust in question, and therefore belong not to the present place. And thus we have 13 subdivisions of offences against trust, viz. 1. Wrongful non-investment of trust; 2. Wrongful interception of trust; 3. Wrongful divestment of trust; 4. Usurpation of trust; 5. Wrongful investment or attribution of trust; 6. Wrongful abdication of trust; 7. Wrongful detractation of trust; 8. Wrongful imposition of trust; 9. Negative breach of trust; 10. Positive breach of trust; 11. Abuse of trust; 12. Disturbance of trust; 13. Bribery. From what has been said, it appears that there cannot be any other offences on the part of a trustee by which a beneficiary can receive on any particular occasion any assignable specific prejudice. One sort of acts, however, there are by which a trustee may be put in some danger of receiving a prejudice, although neither the nature of the prejudice nor the occasion on which he is in danger of receiving it should be assignable. These can be no other than such acts, whatever they may be, as dispose the trustee to be acted upon by a given bribe with greater effect than any with which he could otherwise be acted upon; or, in other words, which place him in such circumstances as have a tendency to increase the quantum of his sensibility to the action of any motive of the sort in question. Of these acts there seem to be no others that will admit of a description applicable to all places and times alike than acts of prodigality on the part of the trustee. But in acts of this nature the prejudice to the beneficiary is contingent only and unliquidated, while the prejudice to the trustee himself is certain and liquidated. If therefore on any occasion it should be found advisable to treat it on the footing of an offence, it will find its place more naturally in the class of self-regarding ones. As to the subdivisions of offences against trust, these are perfectly analogous to those of offences by falsehood. The trust may be private, semi-public, or public; it may concern property, person, reputation, or condition, or any two or more of those articles at a time, as will be more particularly explained in another place. Here too the offence, in running over the ground occupied by the three prior classes, will in some instances change its name, while in others it will not. Lastly, if it be asked what sort of relation there subsists between falsehoods on one hand, and offences concerning trust on the other hand, the answer is, they are altogether disparate. Falsehood is a circumstance that may enter into the composition of any sort of offence, those concerning trust as well as any other; in some as an accidental, in others as an essential instrument. Breach or abuse of trust are circumstances which, in the character of accidental concomitants, may enter into the composition of any other offences, those against falsehood included, besides those to which they respectively give name. Chapter 16, paragraph 2.
Chapter 16 of an Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Ruth Golding. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16. Division of Offences. Paragraph 3. Genera of Class 1. Returning now to Class the First, let us pursue the distribution a step farther, and branch out the several divisions of that class, as above exhibited, into their respective genera, that is, into such minuter divisions as are capable of being characterized by denominations of which a great part are already current among the people. In this place the analysis must stop. To apply it in the same regular form to any of the other classes seems scarcely practicable. To semi-public as also to public offences, on account of the interference of local circumstances; to self-regarding ones, on account of the necessity it would create of deciding prematurely upon points which may appear liable to controversy; to offences by falsehood and offences against trust, on account of the dependence there is between this class and the three former. What remains to be done in this way with reference to these four classes will require discussion, and will therefore be introduced with more propriety in the body of the work than in a preliminary part, of which the business is only to draw outlines. An act by which the happiness of an individual is disturbed is either simple in its effects or complex. It may be styled simple in its effects when it affects him in one only of the articles or points in which his interest, as we have seen, is liable to be affected; complex when it affects him in several of those points at once. Such as are simple in their effects must of course be first considered. In a simple way, that is in one way at a time, a man's happiness is liable to be disturbed either (1) by actions referring to his own person itself, or (2) by actions referring to such external objects on which his happiness is more or less dependent. As to his own person, it is composed of two different parts, or reputed parts, his body and his mind. Acts which exert a pernicious influence on his person, whether it be on the corporeal or on the mental part of it, will operate thereon either immediately and without affecting his will, or mediately through the intervention of that faculty, viz., by means of the influence which they cause his will to exercise over his body. If with the intervention of his will, it must be by mental coercion, that is, by causing him to will to maintain, and thence actually to maintain, a certain conduct which it is disagreeable, or in any other way pernicious, to him to maintain. This conduct may either be positive or negative. When positive, the coercion is styled compulsion or constraint; when negative, restraint. Now, the way in which the coercion is disagreeable to him may be by producing either pain of body or only pain of mind. If pain of body is produced by it, the offence will come as well under this as under other denominations, which we shall come to presently. Moreover, the conduct which a man by means of the coercion is forced to maintain will be determined either specifically and originally by the determination of the particular acts themselves which he is forced to perform or to abstain from, or generally and incidentally by means of his being forced to be or not to be in such or such a place. But if he is prevented from being in one place, he is confined thereby to another. For the whole surface of the earth, like the surface of any greater or lesser body, may be conceived to be divided into two, as well as into any other number of parts or spots. If the spot, then, which he is confined to, be smaller than the spot which he is excluded from, his condition may be called confinement; if larger, banishment. Whether an act, the effect of which is to exert a pernicious influence on the person of him who suffers by it, operates with or without the intervention of an act of his will, the mischief it produces will either be mortal or not mortal. If not mortal, it will either be reparable, that is temporary, or irreparable, that is perpetual. If reparable, the mischievous act may be termed a simple corporal injury; if irreparable, an irreparable corporal injury. Lastly, a pain that a man experiences in his mind will either be a pain of actual sufferance or a pain of apprehension. If a pain of apprehension, either the offender himself is represented as intending to bear a part in the production of it, or he is not. In the former case, the offence may be styled menacement; in the latter case, as also where the pain is a pain of actual sufferance, a simple mental injury. And thus we have 9 genera or kinds of personal injuries, which, when ranged in the order most commodious for examination, will stand as follows, viz. 1. Simple corporal injuries. 2. Irreparable corporal injuries. 3. Simple injurious restrainment. 4. Simple injurious compulsion. 5. Wrongful confinement. 6. Wrongful banishment. 7. Wrongful homicide. 8. Wrongful menacement. 9. Simple mental injuries. We come now to offences against reputation merely. These require but few distinctions. In point of reputation there is but one way of suffering, which is by losing a portion of the goodwill of others. Now, in respect of the goodwill which others bear you, you may be a loser in either of two ways: 1. By the manner in which you are thought to behave yourself; and 2. By the manner in which others behave, or are thought to behave, towards you. To cause people to think that you yourself have so behaved as to have been guilty of any of those acts which cause a man to possess less than he did before of the good will of the community, is what may be styled defamation. But such is the constitution of human nature, and such the force of prejudice, that a man merely by manifesting his own want of good will towards you, though ever so unjust in itself, and ever so unlawfully expressed, may, in a manner, force others to withdraw from you a part of theirs. When he does this by words, or by such actions as have no other effect than in as far as they stand in the place of words, the offence may be styled vilification. When it is done by such actions as, besides their having this effect, are injuries to the person, the offence may be styled a personal insult. If it has got the length of reaching the body, a corporal insult. If it stopped short before it reached that length, it may be styled insulting menacement. And thus we have two genera or kinds of offences against reputation merely, to wit, 1. Defamation, and 2. Vilification or revilement. As to corporal insults and insulting menacement, they belong to the compound title of offences against person and reputation, both together. If the property of one man suffers by the delinquency of another, such property either was in trust with the offender or it was not. If it was in trust, the offence is a breach of trust, and of whatever nature it may be in other respects, may be styled dissipation in breach of trust, or dissipation of property in trust. This is a particular case; the opposite one is the more common. In such case the several ways in which property may, by possibility, become the object of an offence may be thus conceived. Offences against property, of whatever kind it be, may be distinguished, as hath been already intimated, into such as concern the legal possession of it or right to it, and such as concern only the enjoyment of it, or, what is the same thing, the exercise of that right. Under the former of these heads come, as hath been already intimated, the several offences of wrongful non-investment, wrongful interception, wrongful divestment, usurpation, and wrongful attribution. When in the commission of any of these offences a falsehood has served as an instrument, and that, as it is commonly called, a wilful, or as it might more properly be termed an advised one, the epithet fraudulent may be prefixed to the name of the offence, or substituted in the room of the word wrongful. The circumstance of fraudulency then may serve to characterize a particular species, comprisable under each of those generic heads. In like manner the circumstance of force, of which more a little farther on, may serve to characterize another. With respect to wrongful interception in particular, the investitive event, by which the title to the thing in question should have accrued to you, and for want of which such title is, through the delinquency of the offender, as it were intercepted, is either an act of his own, expressing it as his will that you should be considered by the law as the person who is legally in possession of it, or it is any other event at large. In the former case, if the thing of which you should have been put into possession is a sum of money to a certain amount, the offence is that which has received the name of insolvency; which branch of delinquency, in consideration of the importance and extent of it, may be treated on the footing of a distinct genus of itself. Next, with regard to such of the offences against property as concern only the enjoyment of the object in question. This object must be either a service or set of services, which should have been rendered by some person, or else an article belonging to the class of things. In the former case, the offence may be styled wrongful withholding of services. In the latter case, it may admit of farther modifications, which may be thus conceived: when any object which you have had the physical occupation or enjoyment of ceases in any degree in consequence of the act of another man, and without any change made in so much of that power as depends upon the intrinsic physical condition of your person, to be subject to that power. This cessation is either owing to change in the intrinsic condition of the thing itself, or in its exterior situation with respect to you, that is, to its being situated out of your reach. In the former case, the nature of the change is either such as to put it out of your power to make any use of it at all, in which case the thing is said to be destroyed, and the offence whereby it is so treated may be termed wrongful destruction, or such only as to render the uses it is capable of being put to of less value than before, in which case it is said to be damaged, or to have sustained damage, and the offence may be termed wrongful endamagement. Moreover, in as far as the value which a thing is of to you is considered as being liable to be in some degree impaired by any act on the part of any other person exercised upon that thing, although on a given occasion no perceptible damage should ensue, the exercise of any such act is commonly treated on the footing of an offence, which may be termed wrongful using or occupation. If the cause of the thing's failing in its capacity of being of use to you lies in the exterior situation of it with relation to you, the offence may be styled wrongful detainment. Wrongful detainment, or detention, during any given period of time, may either be accompanied with the intention of detaining the thing for ever, that is, for an indefinite time, or not. If it be, and if it be accompanied at the same time with the intention of not being amenable to law for what is done, it seems to answer to the idea commonly annexed to the word embezzlement, an offence which is commonly accompanied with breach of trust. In the case of wrongful occupation, the physical faculty of occupying may have been obtained with or without the assistance or consent of the proprietor, or other person appearing to have a right to afford such assistance or consent. If without such assistance or consent, and the occupation be accompanied with the intention of detaining the thing for ever, together with the intention of not being amenable to law for what is done, the offence seems to answer to the idea commonly annexed to the word theft or stealing. If in the same circumstances a force is put upon the body of any person who uses or appears to be disposed to use any endeavours to prevent the act, this seems to be one of the cases in which the offence is generally understood to come under the name of robbery. If the physical faculty in question was obtained with the assistance or consent of a proprietor or other person above spoken of, and still the occupation of the thing is an offence, it may have been either because the assistance or consent was not fairly, or because it was not freely obtained. If not fairly obtained, it was obtained by falsehood, which, if advised, is in such a case termed fraud, and the offence, if accompanied with the intention of not being amenable to law, may be termed fraudulent obtainment or defraudment. If not freely obtained, it was obtained by force, to wit, either by a force put upon the body which has been already mentioned, or by a force put upon the mind. If by a force put upon the mind, or in other words by the application of coercive motives, it must be by producing the apprehension of some evil, which evil, if the act is an offence, must be some evil to which on the occasion in question the one person has no right to expose the other. This is one case in which, if the offence be accompanied with the intention of detaining the thing for ever, whether it be or be not accompanied with the intention of not being amenable to law, it seems to agree with the idea of what is commonly meant by extortion. Now, the part a man takes in exposing another to the evil in question must be either a positive or a negative part. In the former case, again, the evil must either be present or distant. In the case, then, where the assistance or consent is obtained by a force put upon the body, or where, if by a force put upon the mind, the part taken in the exposing a man to the apprehension of the evil is positive, the evil present, and the object of it his person, and if at any rate the extortion thus applied be accompanied with the intention of not being amenable to law, it seems to agree with the remaining case of what goes under the name of robbery. As to dissipation in breach of trust, this, when productive of a pecuniary profit to the trustee, seems to be one species of what is commonly meant by peculation. Another, and the only remaining one, seems to consist in acts of occupation exercised by the trustee upon the things which are the objects of the fiduciary property, for his own benefit and to the damage of the beneficiary. As to robbery, this offence, by the manner in which the assistance or consent is obtained, becomes an offence against property and person at the same time. Dissipation in breach of trust and peculation may perhaps be more commodiously treated of under the head of offences against trust. After these exceptions we have 13 genera or principal kinds of offences against property, which, when ranged in the order most commodious for examination, may stand as follows, viz. 1. Wrongful non-investment of property. 2. Wrongful interception of property. 3. Wrongful divestment of property. 4. Usurpation of property. 5. Wrongful investment of property. 6. Wrongful withholding of services. 7. Wrongful destruction or endamagement. 8. Wrongful occupation. 9. Wrongful detainment. 10. Embezzlement. 11. Theft. 12. Defraudment. 13. Extortion. We proceed now to consider offences which are complex in their effects. Regularly, indeed, we should come to offences against condition, but it will be more convenient to speak first of offences by which a man's interest is affected in two of the preceding points at once. First, then, with regard to offences which affect person and reputation together. When any man, by a mode of treatment which affects the person, injures the reputation of another, his end and purpose must have been either his own immediate pleasure, or that sort of reflected pleasure which in certain circumstances may be reaped from the suffering of another. Now, the only immediate pleasure worth regarding, which any one can reap from the person of another, and which at the same time is capable of affecting the reputation of the latter, is the pleasure of the sexual appetite. This pleasure, then, if reaped at all, must have been reaped either against the consent of the party or with consent. If with consent, the consent must have been obtained either freely and fairly both, or freely but not fairly, or else not even freely, in which case the fairness is out of the question. If the consent be altogether wanting, the offence is called rape. If not fairly obtained, seduction simply. If not freely, it may be called forcible seduction. In any case, either the offence has gone the length of consummation, or has stopped short of that period. If it has gone that length, it takes one or other of the names just mentioned. If not, it may be included alike in all cases under the denomination of a simple lascivious injury. Lastly, to take the case where a man injuring you in your reputation, by proceedings that regard your person, does it for the sake of that sort of pleasure which will sometimes result from the contemplation of another's pain. Under these circumstances, either the offence has actually gone the length of a corporal injury, or it has rested in menacement. In the first case it may be styled a corporal insult. In the other it may come under the name of insulting menacement. And thus we have 6 genera or kind of offences against person and reputation together, which, when ranged in the order most commodious for consideration, will stand thus: 1. corporal insults. 2. Insulting menacement. 3. Seduction. 4. Rape. 5. Forcible seduction. 6. Simple lascivious injuries. Secondly, with respect to those which affect person and property together, that a force put upon the person of a man may be among the means by which the title to property may be unlawfully taken away or acquired has been already stated. A force of this sort, then, is a circumstance which may accompany the offences of wrongful interception, wrongful divestment, usurpation, and wrongful investment. But in these cases the intervention of this circumstance does not happen to have given any new denomination to the offence. In all or any of these cases, however, by prefixing the epithet forcible, we may have so many names of offences which may either be considered as constituting so many species of the genera belonging to the division of offences against property, or as so many genera belonging to the division now before us. Among the offences that concern the enjoyment of the thing, the case is the same with wrongful destruction and wrongful endamagement, as also with wrongful occupation and wrongful detainment. As to the offence of wrongful occupation, it is only in the case where the thing occupied belongs to the class of immovables that, when accompanied by the kind of force in question, has obtained a particular name which is in common use. In this case it is called forcible entry. Forcible detainment, as applied also to immovables, but only to immovables, has obtained, among lawyers at least, the name of forcible detainer. And thus we may distinguish 10 genera or kinds of offences against person and property together, which, omitting for conciseness' sake the epithet wrongful, will stand thus: 1. Forcible interception of property. 2. Forcible divestment of property. 3. Forcible usurpation. 4. Forcible investment. 5. Forcible destruction or endamagement. 6. Forcible occupation of movables. 7. Forcible entry. 8. Forcible detainment of movables. 9. Forcible detainment of immovables. 10. Robbery. We come now to offences against condition. A man's condition or station in life is constituted by the legal relation he bears to the persons who are about him; that is, as we have already had occasion to show, by duties, which by being imposed on one side give birth to rights or powers on the other. These relations, it is evident, may be almost infinitely diversified. Some means, however, may be found of circumscribing the field within which the varieties of them are displayed. In the first place, they must either be such as are capable of displaying themselves within the circle of a private family, or such as require a larger space. The conditions constituted by the former sort of relations may be styled domestic, those constituted by the latter civil. As to domestic conditions, the legal relations by which they are constituted may be distinguished into 1. Such as are superadded to relations purely natural, and 2. Such as, without any such natural basis, subsist purely by institution. By relations purely natural, I mean those which may be said to subsist between certain persons in virtue of the concern which they themselves, or certain other persons, have had in the process which is necessary to the continuance of the species. These relations may be distinguished in the first place into contiguous and uncontiguous. The uncontiguous subsist through the intervention of such as are contiguous. The contiguous may be distinguished in the first place into connubial and postconnubial. Those which may be termed connubial are two: one, that which the male bears towards the female; two, that which the female bears to the male. The post connubial are either productive or derivative. The productive is that which the male and female above mentioned bear each of them towards the children who are the immediate fruit of their union. This is termed the relation of parentality. Now, as the parents must be, so the children may be, of different sexes. Accordingly, the relation of parentality may be distinguished into four species. 1. That which a father bears to his son. This is termed paternity. 2. That which a father bears to his daughter. This also is termed paternity. 3. That which a mother bears to her son. This is called maternity. 4. That which a mother bears to her daughter. This also is termed maternity. Uncontiguous natural relations may be distinguished into immediate and remote. Such as are immediate are what one person bears to another in consequence of their bearing each of them one simple relation to some third person. Thus the paternal grandfather is related to the paternal grandson by means of the two different kinds which together they bear to the father; the brother on the father's side to the brother by means of the two relations of the same kind which together they bear to the father. In the same manner we might proceed to find places in the system for the infinitely diversified relations which result from the combinations that may be formed by mixing together the several sorts of relationships by ascent, relationships by descent, collateral relationships, and relationships by affinity, which latter, when the union between the two parties through whom the affinity takes place is sanctioned by matrimonial solemnities, are termed relationships by marriage. But this, as it would be a most intricate and tedious task, so happily is it for the present purpose an unnecessary one. The only natural relations to which it will be necessary to pay any particular attention are those which, when sanctioned by law, give birth to the conditions of husband and wife, the two relations comprised under the head of parentality, and the corresponding relations comprised under the head of filiality or filiation. What then are the relations of a legal kind which can be superinduced upon the above mentioned natural relations? They must be such as it is the nature of law to give birth to and establish. But the relations which subsist purely by institution exhaust, as we shall see, the whole stock of relationships which it is in the nature of the law to give birth to and establish. The relations then which can be superinduced upon those which are purely natural cannot be in themselves any other than what are of the number of those which subsist purely by institution; so that all the difference there can be between a legal relation of the one sort and a legal relation of the other sort is, that in the former case the circumstance which gave birth to the natural relation serves as a mark to indicate where the legal relation is to fix. In the latter case, the place where the legal relation is to attach is determined not by that circumstance but by some other. From these considerations it will appear manifestly enough that for treating of the several sorts of conditions, as well natural as purely conventional, in the most commodious order, it will be necessary to give the precedence to the latter. Proceeding throughout upon the same principle, we shall all along give the priority not to those which are first by nature, but to those which are most simple in point of description. There is no other way of avoiding perpetual anticipations and repetitions. End of chapter 16, paragraph 3, part A.
Chapter 16, Part 3b of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16, Part 3b. Genera of Class 1. We now come to consider the domestic or family relations, which are purely of legal institution. It is to these in effect that both kinds of domestic conditions, considered as the work of law, are indebted for their origin. When the law, no matter for what purpose, takes upon itself to operate in a matter in which it has not operated before, it can only be by imposing obligation. Now, when a legal obligation is imposed on any man, there are but two ways in which it can, in the first instance, be enforced. The one is by giving the power of enforcing it to the party in whose favour it is imposed. The other is by reserving that power to certain third persons, who, in virtue of their possessing it, are styled ministers of justice. In the first case, the party favoured is said to possess not only a right as against the party obliged, but also a power over him. In the second case, a right only, uncorroborated by power. In the first case, the party favoured may be styled a superior, and as they are both members of the same family, a domestic superior with reference to the party obliged, who, in the same case, may be styled a domestic inferior with reference to the party favoured. Now, in point of possibility, it is evident that domestic conditions, or a kind of fictitious possession analogous to domestic conditions, might have been looked upon as constituted as well by rights alone, without powers on either side, as by powers. But in point of utility, it does not seem expedient, and in point of fact probably owing to the invariable perception which men must have of the inexpediency, no such conditions seem ever to have been constituted by such feeble bands. Of the legal relationships, then, which are capable of being made to subsist within the circle of a family, there remain those only in which the obligation is enforced by power. Now, then, wherever such power is conferred, the end or purpose for which it was conferred, and thus the legislator can be supposed to act without a motive, must have been the producing of a benefit to somebody. In other words, it must have been conferred for the sake of somebody. The person, then, for whose sake it is conferred, must either be one of the two parties just mentioned, or a third party. If one of those two, it must be either the superior or the inferior. If the superior, such superior is commonly called a master, and the inferior is termed his servant, and the power may be termed a beneficial one. If it be for the sake of the inferior that the power is established, the superior is termed a guardian, and the inferior his ward, and the power, being thereby coupled with a trust, may be termed a fiduciary one. If for the sake of a third party, the superior may be termed a superintendent, and the inferior his subordinate. This third party will either be an assignable individual, or a set of individuals, or a set of unassignable individuals. In this latter case, the trust is either a public or a semi-public one, and the condition which it constitutes is not of the domestic, but of the civil kind. In the former case, this third party or principal, as he may be termed, either has a beneficial power over the superintendent, or he has not. If he has, the superintendent is his servant, and consequently so also is the subordinate. If not, the superintendent is the master of the subordinate, and all the advantage which the principal has over his superintendent is that of possessing a set of rights, uncorroborated by power, and therefore, as we have seen, not fit to constitute a condition of the domestic kind. But be the condition what it may which is constituted by these rights, of what nature can the obligations be, to which the superintendent is capable of being subjected by means of them? They are neither more nor less than those which a man is capable of being subjected to by powers. It follows, therefore, that the functions of a principal and his superintendent coincide with those of a master and his servants, and consequently that the offences relative to the two former conditions will coincide with the offences relative to the two latter. Offences to which the condition of a master, like any other kind of condition, is exposed, may, as hath been already intimated, be distinguished into such as concern the existence of the condition itself, and such as concern the performance of the functions of it, while subsisting. First, then, with regard to such as affect its existence. It is obvious enough that the services of one man may be of benefit to another. The condition of a master may therefore be a beneficial one. It stands exposed, therefore, to the offences of wrongful non-investment, wrongful interception, usurpation, wrongful investment, and wrongful divestment. But how should it stand exposed to the offences of wrongful abdication, wrongful detrication, and wrongful imposition? Certainly it cannot of itself, for services, when a man has the power of exacting them or not, as he thinks fit, can never be a burden. But if to the powers by which the condition of a master is constituted, the law thinks fit to annex any obligation on the part of the master, for instance that of affording maintenance, or giving wages to the servant, or paying money to anybody else, it is evident that in virtue of such obligation the condition may become a burden. In this case, however, the condition possessed by the master will not, properly speaking, be the pure and simple condition of a master. It will be a kind of complex object, resolvable into the beneficial condition of a master and the burthensome obligation which is annexed to it. Still, however, if the nature of the obligation lies within a narrow compass, and does not, in the manner of that which constitutes a trust, interfere with the exercise of those powers by which the condition of the superior is constituted, the latter, notwithstanding this foreign mixture, will still retain the name of mastership. In this case, therefore, but not otherwise, the condition of a master may stand exposed to the offences of wrongful abdication, wrongful detrication, and wrongful imposition. Next, as to the behaviour of persons with reference to this condition while considered as subsisting. In virtue of it being a benefit, it is exposed to disturbance. This disturbance will either be the offence of a stranger or the offence of the servant himself. Where it is the offence of a stranger, and is committed by taking the person of the servant, in circumstances in which the taking of an object belonging to the class of things would be an act of theft, or, what is scarcely worth distinguishing from theft, an act of embezzlement, it may be termed servant stealing. Where it is an offence of the servant himself, it is styled breach of duty. Now, the most flagrant species of breach of duty, and that which includes indeed every other, is that which consists in the servant's withdrawing himself from the place in which the duty should be performed. This species of breach of duty is termed elopement. Again, in virtue of the power belonging to this condition, it is liable, on the part of the master, to abuse, but this power is not coupled with a trust. The condition of a master is therefore not exposed to any offence, which is analogous to breach of trust. Lastly, on account of it being exposed to abuse, it may be conceived to stand, in point of possibility, exposed to bribery. But considering how few and how insignificant the persons are who are liable to be the subject to the power here in question, this is an offence which, on account of the want of temptation, there will seldom be any example of in practice. We may therefore reckon 13 sorts of offences to which the condition of a master is exposed, viz. 1. Wrongful non-investment of mastership. 2. Wrongful interception of mastership. 3. Wrongful divestment of mastership. 4. Usurpation of mastership. 5. Wrongful investment of mastership. 6. Wrongful abdication of mastership. 7. Wrongful detraction of mastership. 8. Wrongful imposition of mastership. 9. Abuse of mastership. 10. Disturbance of mastership. 11. Breach of duty in servants. 12. Elopement of servants. 13. Service stealing. As to the power by which the condition of a master is constituted, this may be either limited or unlimited. When it is altogether unlimited, the condition of the servant is styled pure slavery. But as the rules of language are as far as can be conceived from being steady on this head, the term slavery is commonly made use of wherever the limitations prescribed to the power of the master are looked upon as inconsiderable. Whenever any such limitation is prescribed, a kind of fictitious entity is thereby created, and in quality of an incorporeal object of possession is bestowed upon the servant. This object is of the class of those which are called rights, and in the present case is termed in a more particular manner a liberty, and sometimes a privilege, an immunity, or an exemption. Now these limitations on one hand, and these liberties on the other, may, it is evident, be as various as the acts, positive or negative, which the master may or may not have the power of obliging the servants to submit to or to perform. Correspondent then to the infinitude of these liberties is the infinitude of the modification which the condition of mastership, or, as it is more common to say in such a case, that of servitude, admits of. These modifications, it is evident, may, in different countries, be infinitely diversified. In different countries, therefore, the offence characterized by the above names will, if specifically considered, admit of very different descriptions. If there be a spot upon the earth so wretched as to exhibit the spectacle of pure and absolutely unlimited slavery, on that spot there will be no such thing as any abuse of mastership, which means neither more nor less than no abuse of mastership will there be treated on the footing of an offence. As to the question whether any and what modes of servitude ought to be established or kept on foot, this is a question, the solution of which belongs to the civil branch of the art of legislation. Next, with regard to the offences that may concern the condition of a servant. It might seem at first sight that a condition of this kind could not have a spark of benefit belonging to it, that it could not be attended with any other consequences than such as rendered it a mere burthen. But a burthen itself may be a benefit, in comparison of a greater burthen. Conceive a man's situation then to be such, that he must, at any rate, be in a state of pure slavery. Still may it be material to him, and highly material, who the person is whom he has for his master. A state of slavery then under one master may be a beneficial state to him in comparison with a state of slavery under another master. The condition of a servant then is exposed to the several offences to which a condition, in virtue of it being a beneficial one, is exposed. More than this, where the power of the master is limited, and the limitations annexed to it, and hence the liberties of the servant are considerable, the servitude may even be positively eligible. For amongst those limitations may be such as sufficient to enable the servant to possess property of his own. Being capable then of possessing property of his own, he may be capable of receiving it from his master. In short, he may receive wages or other emoluments from his master, and the benefit resulting from these wages may be so considerable as to outweigh the burthen of the servitude, and by that means render that condition more beneficial upon the whole, and more eligible than that of one who is not in any respect under the control of any such person as a master. Accordingly, by these means the condition of the servant may be so eligible that his entrance into it and his continuance in it may have been altogether the result of his own choice. That the nature of the two conditions may be the more clearly understood, it may be of use to show the sort of correspondency there is between the offences which affect the existence of the one and those which affect the existence of the other. That this correspondency cannot but be very intimate is obvious at first sight. It is not, however, that a given offence in the former catalogue coincides with an offence of the same name in the latter catalogue. Usurpation of servantship with usurpation of mastership, for example. But the case is that an offence of one denomination in the one catalogue coincides with an offence of a different denomination in the other catalogue. Nor is the coincidence constant and certain, but liable to contingencies, as we shall see. First, then, wrongful non-investment of the condition of a servant, if it be the offence of one who should have been the master, coincides with wrongful detraction of mastership. If it be the offence of a third person, it involves in it non-investment of mastership, which, provided the mastership be in the eyes of him who should have been master a beneficial thing, but not otherwise, is wrongful. Wrongful interception of the condition of a servant, if it be the offence of him who should have been master, coincides with the wrongful detraction of mastership, if it be the offence of a third person, and the mastership being a beneficial thing, it involves in it wrongful interception of mastership. 3. Wrongful divestment of servantship, if it be the offence of the master but not otherwise, coincides with wrongful abdication of mastership. If it be the offence of a stranger, it involves in it divestment of mastership, which, as in far as the mastership is a beneficial thing, is wrongful. 4. Usurpation of servantship coincides necessarily with wrongful imposition of mastership. It will be apt to involve in it wrongful divestment of mastership, but this only in the case where the usurper, previously to the usurpation, was in a state of servitude under some other master. 5. Wrongful investment of servantship, the servantship being considered as a beneficial thing, coincides with imposition of mastership, which, if in the eyes of the pretended master the mastership should chance to be a burden, will be wrongful. 6. Wrongful abdication of servantship coincides with wrongful divestment of mastership. 7. Wrongful detraction of servantship with wrongful non-investment of mastership. 8. Wrongful imposition of servantship, if it be the offence of the pretended master, coincides with usurpation of mastership. If it be the offence of a stranger, it involves in it imposition of mastership, which, if in the eyes of the pretended master the mastership should be a burthen, will be wrongful. As to abuse of mastership, disturbance of mastership, breach of duty in servants, elopement of servants, and servant stealing, these are offences which, without any change of denomination, bear equal relation to both conditions. And thus we may reckon 13 sorts of offences to which the condition of a servant stands exposed, viz. 1. Wrongful non-investment of servantship. 2. Wrongful interception of servantship. 3. Wrongful divestment of servantship. 4. Usurpation of servantship. 5. Wrongful investment of servantship. 6. Wrongful abdication of servantship. 7. Wrongful detraction of servantship. 8. Wrongful imposition of servantship. 9. Abuse of mastership. 10. Disturbance of mastership. 11. Breach of duty in servants. 12. Elopement of servants. 13. Servant stealing. We now come to the offences to which the condition of a guardian is exposed. A guardian is one who is invested with power over another, living within the compass of the same family, and called a ward, the power being to be exercised for the benefit of the ward. Now then, what are the cases in which it can be for the benefit of one man that another, living within the compass of the same family, should exercise power over him? Consider either of the parties by himself, and suppose him, in point of understanding, to be on the level with the other, it seems evident enough that no such cases can ever exist. To the production of happiness on the part of any given person, in like manner as to the production of any other effect which is the result of human agency, three things it is necessary should concur: knowledge, inclination, and physical power. Now, as there is no man who is so sure of being inclined on all occasions to promote your happiness as you yourself are, so neither is there any man who upon the whole can have had so good opportunities as you must have had for knowing what is most conducive to that purpose. For who should know as well as you what it is that gives you pain or pleasure? Moreover, as to power, it is manifest that no superiority in this respect, on the part of a stranger, could, for constancy, make up for so great a deficiency as he must lie under in respect of two such material points as knowledge and inclination. If then there be a case when it can be for the advantage of one man to be under the power of another, it must be on account of some palpable and very considerable deficiency on the part of the former in point of intellects, or, what is the same thing in other words, in point of knowledge or understanding. Now there are two cases in which such palpable deficiency is known to take place. These are, 1. When a man's intellect is not yet arrived at that state in which it is capable of directing his own inclination in the pursuit of happiness. This is the case of infancy. 2. When by some particular known or unknown circumstance his intellect has either never arrived at that state, or having arrived at it has fallen from it, which is the case of insanity. By which means then is it to be ascertained whether a man's intellect is in that state or no? For exhibiting the quantity of sensible heat in the human body we have a very tolerable sort of instrument, the thermometer; but for exhibiting the quantity of intelligence we have no such instrument. It is evident, therefore, that the line which separates the quantity of intelligence which is sufficient for the purpose of self-government from that which is not sufficient must be, in a great measure, arbitrary. Where the insufficiency is the result of want of age, the sufficient quantity of intelligence, be it what it may, does not accrue to all at the same period of their lives. It becomes therefore necessary for legislators to cut the Gordian knot and fix upon a particular period, at which, and not before, truly or not, every person whatever shall be deemed, as far as depends upon age, to be in possession of this sufficient quantity. In this case, then, a line is drawn which may be the same for every man, and in the description of which, such as it is, whatever persons are concerned may be certain of agreeing, the circumstance of time affording a mark by which the line in question may be traced with the utmost degree of nicety. On the other hand, when the insufficiency is the result of insanity, there is not even this resource, so that here the legislator has no other expedient than to appoint some particular person or persons to give a particular determination of the question, in every instant in which it occurs, according to his or their particular and arbitrary discretion. Arbitrary enough it must be at any rate, since the only way in which it can be exercised is by considering whether the share of intelligence possessed by the individual in question does or does not come up to the loose and indeterminate idea which persons so appointed may chance to entertain with respect to the quantity which is deemed sufficient. The line then being drawn, or supposed to be so, it is expedient to a man who cannot with safety to himself be left in his own power, that he should be placed in the power of another. How long then should he remain so? Just so long as his inability is supposed to continue, that is, in the case of infancy, till he arrives at that period at which the law deems him to be of full age; in the case of insanity, till he be of sound mind and understanding. Now it is evident that this period in the case of infancy may not arrive for a considerable time, and in the case of insanity perhaps never. The duration of the power belonging to this trust must, therefore, in the one case be very considerable, in the other case indefinite. The next point to consider is what may be the extent of it, for as to what ought to be, that is a matter to be settled, not in a general analytical sketch, but in a particular and circumstantial dissertation. By possibility, then, this power may possess any extent that can be imagined. It may extend to any acts which, physically speaking, it may be in the power of the ward to perform himself, or be the object of if exercised by the guardian. Conceive the power, for a moment, to stand upon this footing. The condition of the ward stands now exactly upon a footing with pure slavery. Add the obligation by which the power is turned into a trust, the limits of the power are now very considerably narrowed. What then is the purport of this obligation? Of what nature is the course of conduct it prescribes? It is such a course of conduct as shall be best calculated for procuring to the ward the greatest quantity of happiness, which his faculties, and the circumstances he is in, will admit of, saving always in the first place the regard which the guardian is permitted to show to his own happiness, and in the second place that which he is obliged as well as permitted to show to that of other men. This is, in fact, no other than the course of conduct which the ward, did he but know how, ought, in point of prudence, to maintain of himself, so that the business of the former is to govern the latter precisely in the manner in which this latter ought to govern himself. Now, to instruct each individual in what manner to govern his own conduct in the details of life is the particular business of private ethics. To instruct individuals in what manner to govern the conduct of those whose happiness during non-age is permitted to their charge is the business of the art of private education. The details, therefore, of the rules to be given for that purpose, any more than the acts which are capable of being committed in violation of those rules, belong not to the art of legislation, since, as will be seen more particularly hereafter, such details could not, with any chance of advantage, be provided for by the legislator. Some general outlines might indeed be drawn by his authority, and in point of fact some are in every civilized state. But such regulations, it is evident, must be liable to great variation, in the first place according to the infinite diversity of civil conditions which a man may stand invested with in any given state. In the next place, according to the diversity of local circumstances that may influence the nature of the conditions which may chance to be established in different states. On this account, the offences which would be constituted by such regulations could not be comprised under any concise and settled denominations capable of a permanent and extensive application. No place, therefore, can be allotted to them here. End of section 23.
Chapter 16 of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Ruth Golding. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16. Division of Offences. Paragraph 3. Genera of Class 1. Part C. By what has been said, we are the better prepared for taking an account of the offences to which the condition in question stands exposed. Guardianship, being a private trust, is, of course, exposed to those offences and no others by which a private trust is liable to be affected. Some of them, however, on account of the special quality of the trust, will admit of some further particularity of description. In the first place, breach of this species of trust may be termed mismanagement of guardianship. In the second place, of whatever nature the duties are which are capable of being annexed to this condition, it must often happen that in order to fulfil them it is necessary the guardian should be at a certain particular place. Mismanagement of guardianship, when it consists in the not being on the occasion in question at the place in question, may be termed desertion of guardianship. Thirdly, it is manifest enough that the object which the guardian ought to propose to himself in the exercise of the powers to which those duties are annexed, is to procure for the ward the greatest quantity of happiness which can be procured for him, consistently with the regard which is due to the other interests that have been mentioned. For this is the object which the ward would have proposed to himself, and might and ought to have been allowed to propose to himself had he been capable of governing his own conduct. Now, in order to procure this happiness, it is necessary that he should possess a certain power over the objects on the use of which such happiness depends. These objects are either the person of the ward himself, or other objects that are extraneous to him. These other objects are either things or persons. As to things, then, objects of this class, in so far as a man's happiness depends upon the use of them, are styled his property. The case is the same with the services of any persons over whom he may happen to possess a beneficial power, or to whose services he may happen to possess a beneficial right. Now, when property of any kind which is in trust suffers by the delinquency of him with whom it is in trust, such offence, of whatever nature it is in other respects, may be styled dissipation in breach of trust; and if it be attended with a profit to the trustee, it may be styled peculation. Fourthly, for one person to exercise a power of any kind over another, it is necessary that the latter should either perform certain acts, upon being commanded so to do by the former, or at least should suffer certain acts to be exercised upon himself. In this respect a ward must stand upon the footing of a servant, and the condition of a ward must in this respect stand exposed to the same offences to which that of a servant stands exposed; that is, on the part of a stranger, to disturbance, which in particular circumstances will amount to theft; on the part of the ward, to breach of duty, which in particular circumstances may be effected by elopement. Fifthly, there does not seem to be any offence concerning guardianship that corresponds to abuse of trust. I mean in the sense to which the last mentioned denomination has been here confined. The reason is that guardianship, being a trust of a private nature, does not, as such, confer upon the trustee any power, either over the persons or over the property of any party, other than the beneficiary himself. If by accident it confers on the trustee a power over any persons whose services constitute a part of the property of the beneficiary, the trustee becomes thereby, in certain respects, the master of such servants. Sixthly, bribery also is a sort of offence to which, in this case, there is not commonly much temptation. It is an offence, however, which by possibility is capable of taking this direction, and must therefore be aggregated to the number of the offences to which the condition of a guardian stands exposed. And thus we have in all 17 of these offences, viz. 1. Wrongful non-investment of guardianship. 2. Wrongful interception of guardianship. 3. Wrongful divestment of guardianship. 4. Usurpation of guardianship. 5. Wrongful investment of guardianship. 6. wrongful abdication of guardianship. 7. Detractation of guardianship. 8. Wrongful imposition of guardianship. 9. Mismanagement of guardianship. 10. Desertion of guardianship. 11. Dissipation in prejudice of wardship. 12. Peculation in prejudice of wardship. 13. Disturbance of guardianship. 14. Breach of duty to guardians. 15. Elopement from guardians. 16. Ward stealing. 17. Bribery in prejudice of wardship. Next, with regard to offences to which the condition of wardship is exposed. Those which first affect the existence of the condition itself are as follows. 1. Wrongful non-investment of the condition of a ward. This, if it be the offence of one who should have been guardian, coincides with wrongful detractation of guardianship. If it be the offence of a third person, it involves in it non-investment of guardianship, which, provided the guardianship is, in the eyes of him who should have been guardian, a desirable thing, is wrongful. 2. Wrongful interception of wardship. This, if it be the offence of him who should have been guardian, coincides with wrongful detractation of guardianship. If it be the offence of a third person, it involves in it interception of guardianship, which, provided the guardianship is, in the eyes of him who should have been guardian, a desirable thing, is wrongful. 3. Wrongful divestment of wardship. This, if it be the offence of the guardian, but not otherwise, coincides with wrongful abdication of guardianship. If it be the offence of a third person, it involves in it divestment of guardianship, which, if the guardianship is, in the eyes of the guardian, a desirable thing, is wrongful. 4. Usurpation of the condition of a ward, an offence not very likely to be committed. This coincides at any rate with wrongful imposition of guardianship, and if the usurper were already under the guardianship of another guardian, it will involve in it wrongful divestment of such guardianship. 5. Wrongful investment of wardship, the wardship being considered as a beneficial thing. This coincides with imposition of guardianship, which, if in the eyes of the pretended guardian the guardianship should be a burthen, will be wrongful. 6. Wrongful abdication of wardship. This coincides with wrongful divestment of guardianship. 7. Wrongful detractation of wardship. This coincides with wrongful interception of guardianship. 8. Wrongful imposition of wardship. This, if the offender be the pretended guardian, coincides with usurpation of guardianship. If a stranger, it involves in it wrongful imposition of guardianship. As to such of the offences relative to this condition as concern the consequences of it while subsisting, they are of such a nature that, without any change of denomination, they belong equally to the condition of a guardian and that of a ward. We may therefore reckon 17 sorts of offences relative to the condition of a ward. 1. Wrongful non-investment of wardship. 2. Wrongful interception of wardship. 3. Wrongful divestment of wardship. 4. Usurpation of wardship. 5. Wrongful investment of wardship. 6. Wrongful abdication of wardship. 7. Wrongful detractation of wardship. 8. Wrongful imposition of wardship. 9. Mismanagement of guardianship. 10. Desertion of guardianship. 11. Dissipation in prejudice of wardship. 12. Peculation in prejudice of wardship. 13. Disturbance of guardianship. 14. Breach of duty to guardians. 15. Elopement from guardians. 16. Ward stealing. 17. Bribery in prejudice of wardship. We come now to the offences to which the condition of a parent stands exposed, and first with regard to those by which the very existence of the condition is affected. On this occasion, in order to see the more clearly into the subject, it will be necessary to distinguish between the natural relationship and the legal relationship, which is superinduced, as it were, upon the natural one. The natural one being constituted by a particular event, which either on account of its being already past, or on some other account, is equally out of the power of the law, neither is nor can be made the subject of an offence. Is a man your father? It is not any offence of mine that can make you not his son. Is he not your father? It is not any offence of mine that can render him so. But although he does in fact bear that relation to you, I, by an offence of mine, may perhaps so manage matters that he shall not be thought to bear it, which, with respect to any legal advantages which either he or you could derive from such relationship, will be the same thing as if he did not. In the capacity of a witness, I may cause the judges to believe that he is not your father, and to decree accordingly; or, in the capacity of a judge, I may myself decree him not to be your father. Leaving then the purely natural relationship as an object equally out of the reach of justice and injustice, the legal condition, it is evident, will stand exposed to the same offences, neither more nor less, as every other condition that is capable of being either beneficial or burthensome stands exposed to. Next, with regard to the exercise of the functions belonging to this condition, considered as still subsisting. In parentality there must be two persons concerned, the father and the mother. The condition of a parent includes, therefore, two conditions, that of a father and that of a mother, with respect to such or such a child. Now, it is evident that between these two parties, whatever beneficiary powers and other rights, as also whatever obligations are annexed to the condition of a parent, may be shared in any proportions that can be imagined. But if in these several objects of legal creation each of these two parties have severally a share, and if the interests of all these parties are in any degree provided for, it is evident that each of the parents will stand, with relation to the child, in two several capacities, that of a master and that of a guardian. The condition of a parent, then, in as far as it is the work of law, may be considered as a complex condition, compounded of that of a guardian and that of a master. To the parent, then, in quality of guardian, results a set of duties, involving, as necessary to the discharge of them, certain powers. To the child, in the character of a ward, a set of rights corresponding to the parent's duties, and a set of duties corresponding to his powers. To the parent again, in quality of master, a set of beneficiary powers, without any other necessary limitation, so long as they last, than what is annexed to them by the duties incumbent on him in quality of a guardian. To the child, in the character of a servant, a set of duties corresponding to the parent's beneficiary powers, and without any other necessary limitation, so long as they last, than what is annexed to them by the rights which belong to the child in his capacity of ward. The condition of a parent will therefore be exposed to all the offences to which either that of a guardian or that of a master are exposed. and as each of the parents will partake more or less of both those characters, the offences to which the two conditions are exposed may be nominally, as they will be substantially, the same. Taking them, then, all together, the offences to which the condition of a parent is exposed will stand as follows: 1. Wrongful non-investment of parentality. 2. Wrongful interception of parentality. 3. Wrongful divestment of parentality. 4. Usurpation of parentality. 5. Wrongful investment of parentality. 6. Wrongful abdication of parentality. 7. Wrongful detractation of parentality. 8. Wrongful imposition of parentality. 9. Mismanagement of parental guardianship. 10. Desertion of parental guardianship. 11. Dissipation in prejudice of filial wardship. 12. Peculation in prejudice of filial wardship. 13. Abuse of parental powers. 14. Disturbance of parental guardianship. 15. Breach of duty to parents. 16. Elopement from parents. 17. Child stealing. 18. Bribery in prejudice of filial wardship. Next, with regard to the offences to which the filial condition, the condition of a son or daughter, stands exposed. The principles to be pursued in the investigation of offences of this description have already been sufficiently developed. It will be sufficient, therefore, to enumerate them without further discussion. The only peculiarities by which offences relative to the condition in question stand distinguished from the offences relative to all the preceding conditions depend upon this one circumstance, viz., that it is certain every one must have had a father and a mother, at the same time that it is not certain that every one must have had a master, a servant, a guardian, or a ward. It will be observed all along that where a person from whom, if alive, the benefit would be taken, or on whom the burthen would be imposed, be dead, so much of the mischief is extinct along with the object of the offence. There still, however, remains so much of the mischief as depends upon the advantage or disadvantage which might accrue to persons related or supposed to be related in the several remoter degrees to him in question. The catalogue, then, of these offences stands as follows: 1. Wrongful non-investment of filiation. This, if it be the offence of him or her who should have been recognised as the parent, coincides with wrongful detractation of parentality. If it be the offence of a third person, it involves in it non-investment of parentality, which, provided the parentality is, in the eyes of him or her who should have been recognised as the parent, a desirable thing, is wrongful. 2. Wrongful interception of filiation. This, if it be the offence of him or her who should have been recognised as the parent, coincides with wrongful detractation of parentality. If it be the offence of a third person, it involves in it interception of parentality, which, provided the parentality is, in the eyes of him or her who should have been recognised as parent, a desirable thing, is wrongful. 3. Wrongful divestment of filiation. This, if it be the offence of him or her who should be recognised as parent, coincides with wrongful abdication of parentality. If it be the offence of a third person, it involves in it divestment of parentality, to wit, of paternity, or of maternity, or of both, which, if the parentality is, in the eyes of him or her who should be recognised as parent, a desirable thing, are respectively wrongful. 4. Usurpation of filiation. This coincides with wrongful imposition of parentality, to wit either of paternity or of maternity or of both, and necessarily involves in it divestment of parentality, which, if the parentality thus divested were, in the eyes of him or her who are thus divested of it, a desirable thing, is wrongful. 5. Wrongful investment of filiation, the filiation being considered as a beneficial thing. This coincides with imposition of parentality, which, if in the eyes of the pretended father or mother the parentality should be an undesirable thing, will be wrongful. 6. Wrongful abdication of filiation. This necessarily coincides with wrongful divestment of parentality. It also is apt to involve in it wrongful imposition of parentality, though not necessarily either to the advantage or to the prejudice of any certain person. For if a man, supposed at first to be your son, appears afterwards not to be yours, it is certain indeed that he is the son of some other man, but it may not appear who that other man is. 7. Wrongful detractation of filiation. This coincides with wrongful non-investment or wrongful interception of parentality. 8. Wrongful imposition of filiation. This, if it be the offence of the pretended parent, coincides necessarily with usurpation of parentality. If it be the offence of a third person, it necessarily involves imposition of parentality, as also divestment of parentality, either or both of which, according to the circumstance above mentioned, may or may not be wrongful. 9. Mismanagement of parental guardianship. 10. Desertion of parental guardianship. 11. Dissipation in prejudice of filial wardship. 12. Peculation in prejudice of filial wardship. 13. Abuse of parental power. 14. Disturbance of parental guardianship. 15. Breach of duty to parents. 16. Elopement from parents. 17. Child stealing. 18. Bribery in prejudice of parental guardianship. We shall now be able to apply ourselves with some advantage to the examination of the several offences to which the marital condition, or condition of a husband, stands exposed. A husband is a man between whom and a certain woman, who in this case is called his wife, there subsists a legal obligation for the purpose of their living together, and in particular for the purpose of a sexual intercourse to be carried on between them. This obligation will naturally be considered in 4 points of view. 1. In respect of its commencement. 2. In respect of the placing of it. 3. In respect of the nature of it. 4. In respect of its duration. First, then, it is evident that in point of possibility one method of commencement is as conceivable as another. The time of its commencement might have been marked by one sort of event, by one sort of signal, as it may here be called, as well as by another. But in practice the signal has usually been, as in point of utility it ought constantly to be, a contract entered into by the parties, that is, a set of signs pitched upon by the law as expressive of their mutual consent to take upon them this condition. Secondly and thirdly, with regard to the placing of the obligations which are the result of the contract, it is evident that they must rest either solely on one side or mutually on both. on the first supposition, the condition is not to be distinguished from pure slavery. In this case, either the wife must be the slave of the husband, or the husband of the wife. The first of these suppositions has perhaps never been exemplified, the opposing influence of physical causes being too universal to have ever been surmounted. The latter seems to have been exemplified but too often, perhaps among the first Romans, at any rate in many barbarous nations. Thirdly, with regard to the nature of the obligations. If they are not suffered to rest all on one side, certain rights are thereby given to the other. There must therefore be rights on both sides. Now, where there are mutual rights possessed by two persons as against each other, either there are powers annexed to those rights or not. But the persons in question are, by the supposition, to live together, in which case we have shown that it is not only expedient, but in a manner necessary, that on one side there should be powers. Now it is only on one side that powers can be, for suppose them on both sides, and they destroy one another. The question is, then, in which of the parties these powers shall be lodged. We have shown that on the principle of utility they ought to be lodged in the husband. The powers, then, which subsist being lodged in the husband, the next question is, shall the interest of one party only, or of both, be consulted in the exercise of them? It is evident that on the principle of utility the interests of both ought alike to be consulted, since in two persons taken together more happiness is producible than in one. This being the case, it is manifest that the legal relation which the husband will bear to the wife will be a complex one, compounded of that of master and that of guardian. The offences, then, to which the condition of a husband will be exposed will be the sum of those to which the two conditions of master and guardian are exposed. Thus far the condition of a husband, with respect to the general outlines of it, stands upon the same footing as that of a parent. But there are certain reciprocal services, which, being the main subject of the matrimonial contract, constitute the essence of the two matrimonial relations, and which neither a master nor guardian as such, nor a parent at any rate, have usually been permitted to receive. These must of course have been distinguished from the indiscriminate train of services at large which the husband in his character of master is empowered to exact, and of those which in his character of guardian he is bound to render. Being thus distinguished, the offences relative to the two conditions have, in many instances, in as far as they have reference to these peculiar services, acquired particular denominations. In the first place, with regard to the contract, from the celebration of which the legal condition dates its existence. It is obvious that in point of possibility this contract might, on the part of either sex, subsist with respect to several persons of the other sex at the same time. The husband might have any number of wives, the wife might have any number of husbands. The husband might enter into the contract with a number of wives at the same time, or, if with only one at a time, he might reserve to himself a right of engaging in a similar contract with any number, or with only such or such a number of other women afterwards, during the continuance of each former contract. This latter accordingly is the footing upon which, as is well known, marriage is and has been established in many extensive countries, particularly in all those which profess the Mahometan religion. In point of possibility, it is evident that the like liberty might be reserved on the part of the wife, though in point of practice no examples of such an arrangement seem ever to have occurred. Which of all these arrangements is in point of utility the most expedient is a question which would require too much discussion to answer in the course of an analytical process like the present, and which belongs indeed to the civil branch of legislation rather than to the penal. In Christian countries the solemnization of any such contract is made to exclude the solemnization of any subsequent one during the continuance of a former, and the solemnization of any such subsequent contract is accordingly treated as an offence under the name of polygamy. Polygamy, then, is at any rate on the part of the man a particular modification of that offence which may be styled usurpation of the condition of a husband. As to its other effects, they will be different, according as it was the man only, or the woman only, or both, that were in a state of matrimony at the time of the commission of the offence. If the man only, then his offence involves in it pro tanto that of wrongful divestment of the condition of a wife, in prejudice of his prior wife. If the woman only, then it involves in it pro tanto that of wrongful divestment of the condition of a husband, in prejudice of her prior husband. If both were already married, it of course involves both the wrongful divestments which have just been mentioned. And on the other hand also, the converse of all this may be observed with regard to polygamy on the part of the woman. Secondly, as the engaging not to enter into any subsequent engagement of the like kind during the continuance of the first is one of the conditions on which the law lends its sanction to the first, so another is the inserting as one of the articles of this engagement an undertaking not to render to or accept from any other person the services which form the characteristic object of it. The rendering or acceptance of any such services is accordingly treated as an offence, under the name of adultery, under which name is also comprised the offence of the stranger, who, in the commission of the above offence, is the necessary accomplice. Thirdly, disturbing either of the parties to this engagement in the possession of these characteristic services may, in like manner, be distinguished from the offence of disturbing them in the enjoyment of the miscellaneous advantages derivable from the same condition. And on whichever side the blame rests, whether that of the party or that of a third person, may be termed wrongful withholding of connubial services. And thus we have 21 sorts of offences, to which, as the law stands at present in Christian countries, the condition of a husband stands exposed, viz. 1. Wrongful non-investment of the condition of a husband. 2. Wrongful interception of the condition of a husband. 3. Wrongful divestment of the condition of a husband. 4. Usurpation of the condition of a husband. 5. Polygamy. 6. Wrongful investment of the condition of a husband. 7. Wrongful abdication of the condition of a husband. 8. Wrongful detractation of the condition of a husband. 9. Wrongful imposition of the condition of a husband. 10. Mismanagement of marital guardianship. 11. Desertion of marital guardianship. 12. Dissipation in prejudice of matrimonial wardship. 13. Peculation in prejudice of matrimonial wardship. 14. Abuse of marital power. 15. Disturbance of marital guardianship. 16. wrongful withholding of connubial services. 17. Adultery. 18. Breach of duty to husbands. 19. Elopement from husbands. 20. Wife stealing. 21. Bribery in prejudice of marital guardianship. End of chapter 6, paragraph 3, part C.
Section 25 of an Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16, Paragraph 3, Part D. Next, with regard to the offences to which the condition of a wife stands exposed. From the patterns that have been exhibited already, the coincidence and associations that takes place between the offences that concern the existence of this condition and those which concern the existence of the condition of a husband may easily enough be apprehended without further repetitions. The catalogue of those now under consideration will be precisely the same in every article as the catalogue last exhibited. Thus much for the several sorts of offences relative to the several sorts of domestic conditions, those which are constituted by such natural relations as are contiguous being included. There remain those which are uncontiguous, of which, after so much has been said of the others, it will naturally be expected that some notice should be taken. These, however, do not afford any of that matter which is necessary to constitute a condition. In point of fact, no power seems ever to be annexed to any of them. A grandfather, perhaps, may be called by the law to take upon him the guardianship of his orphan grandson, but then the power he has belongs to him not as a grandfather, but as a guardian. In point of possibility, indeed, power might be annexed to these relations, just as it might to any other. But still no new sort of domestic condition would result from it, since it has been shown that there can be no others that, being constituted by power, shall be distinct from those which have been already mentioned. Such as they are, however, they have this in common with the before-mentioned relations, that they are capable of importing either benefit or burthen. They therefore stand exposed to the several offences whereby those or any other relations are liable to be affected in point of existence. It may be expected, therefore, that in virtue of these offences they should be added to the list of relations which are liable to be objects of delinquency. But the fact is that they already stand included in it, and although not expressly named, let as effectually as if they were. On the one hand, it is only by affecting such or such a contiguous relation that any offence affecting uncontiguous relations can take place. On the other hand, neither can any offence affecting the existence of the contiguous relations be committed without affecting the existence of an indefinite multitude of such as are uncontiguous. A false witness comes and causes it to be believed that you are the son of a woman who in truth is not your mother. What follows? An endless tribe of other false persuasions, that you are the grandson of the father and of the mother of this supposed mother, that you are the son of some husband of hers, or at least of some man with whom she has cohabited, the grandson of his father and mother, and so on, the brother of their other children, if they have any, the brother-in-law of the husbands and wives of those children, if married, the uncle of the children of those children, and so on. On the other hand, that you are not the son of your real mother, nor of your real father, that you are not the grandson of either of your real grandfathers or grandmothers, and so on without end. all which persuasions result from are included in the one original false persuasion of your being the son of this your pretended mother. It should seem, therefore, at first sight, that none of the offences against these uncontiguous relations could ever come expressly into question. For, by the same rule that one ought, so it might seem ought 1,000 others, the offences against the uncontiguous being merged, as it were, in those which affect the contiguous relations. So far, however, is this from being the case, that in speaking of an offence of this stamp, it is not uncommon to hear a great deal said of this or that uncontiguous relationship which it affects, at the same time as no notice at all shall be taken of any of those which are contiguous. How happens this? Because to the uncontiguous relation are annexed perhaps certain remarkable advantages or disadvantages, while to all the intermediate relations none shall be annexed which are a comparison worth noticing. Suppose Antony or Lepidus to have contested the relationship of Octavius, after Augustus, to Caius Julius Caesar. How could it have been done? It could only have been done by contesting either Octavius being the son of Atia, or Atia being the daughter of Julia, or Julia being the daughter of Lucius Julius Caesar, or Lucius Julius Caesar being the father of Caius. But to have been the son of Atia, or the grandson of Julia, or the great-grandson of Lucius Julius Caesar, was in comparison of small importance. These intervening relationships were, comparatively speaking, of no other use to him than in virtue of there being so many necessary links in the genealogical claim which connected him with the sovereign of the empire. As to the advantages and disadvantages which may happen to be annexed to any of these uncontiguous relationships, we have seen already that no powers over the correlative person, nor any corresponding obligations, are of the number. Of what nature, then, can they be? They are, in truth, no other than what are a result either of local and accidental institutions, or of some spontaneous bias that has been taken by the moral sanction. It would therefore be to little purpose to attempt tracing them out a priori by any exhaustive process. All that can be done is to pick up and lay together some of the principal articles in each catalogue by way of specimen. The advantages which a given relationship is apt to impart seem to be referable chiefly to the following heads. 1. Chance of succession to the property or a part of the property of the correlative person. 2. Chance of pecuniary support to be yielded by the correlative person, either by appointment of law or by spontaneous donation. 3. Accession of legal rank, including any legal privileges which may happen to be annexed to it, such as capacity of holding such and such beneficial offices, exemption from such and such burthensome obligations, for instance, paying taxes, serving burthensome offices, etc., etc. 4. Accession of rank by courtesy, including the sort of reputation which is customarily and spontaneously annexed to distinguished birth and family alliance, whereon may depend the chance of advancement in the way of marriage, or in 1,000 other ways less obvious. The disadvantages which a given relation is liable to impart seem to be referable chiefly to the following heads. 1. Chance of being obliged, either by law or by force of the moral sanction, to yield pecuniary support to the correlative party. 2. Loss of legal rank, including the legal disabilities, as well as the burthensome obligations which the law is apt to annex, sometimes with injustice enough, to the lower stations. 3. Loss of rank by courtesy, including the loss of the advantages annexed by custom to such rank. 4. Incapacity of contracting matrimony with the correlative person, where the supposed consanguinity or affinity lies within the prohibited degrees. We now come to civil conditions. These, it may well be imagined, may be infinitely various as the acts which a man may be either commanded or allowed, whether for his own benefit or that of others, to abstain from or to perform. As many different denominations as there are of persons distinguished with a view to such commands and allowances, those denominations only excepted which relate to the conditions above spoken of under the names of domestic one, so many civil conditions one might enumerate. Means, however, more or less explicit, may be found out of circumscribing their infinitude. What the materials are, if they so may be called, of which conditions or any other kind of legal possession can be made up, we have already seen. Beneficial powers, fiduciary powers, beneficial rights, fiduciary rights, relative duties, absolute duties. But as many conditions as import a power or right of the fiduciary kind, as possessed by the person whose condition is in question, belong to the head of trusts. The catalogue of the offences to which these conditions are exposed coincides, therefore, exactly with the catalogue of offences against trust, under which head they have been considered in a general point of view under the head of offences against trust, and such of them as are of a domestic nature in a more particular manner in the character of offences against the several domestic conditions. Conditions constituted by such duties of the relative kind as have for their counterpart trusts constituted by fiduciary powers, as well as rights on the side of the correlative party, and those of a private nature, have also been already discussed under the appellation of domestic conditions. The same observation may be applied to the conditions constituted by such powers of the beneficial kind over persons as of a private nature, as also to the subordinate correlative conditions constituted by the duties corresponding to those rights and powers. As to absolute duties, there is no instance of a condition thus created of which the institution is upon the principle of utility to be justified, unless the several religious conditions of the monastic kind should be allowed of as examples. There remain, as the only materials out of which the conditions which yet remain to be considered can be composed, conditions constituted by beneficial powers over things, conditions constituted by beneficial rights to things, that is, rights to power over things, or by rights to those rights, and so on, conditions constituted by rights to service, and conditions constituted by the duties corresponding to those respective rights. Out of these are to be taken those of which the materials are the ingredients of the several modifications of property, the several conditions of proprietorship. These are the conditions, if such for a moment they may be styled, which, having but here or there any specific names, are not commonly considered on the footing of conditions, so that the acts which if such conditions were recognised might be considered as offences against those conditions, are not wont to be considered in any other light than that of offences against property. Now the case is, as hath been already intimated, that of these civil conditions, those which are wont to be considered under that name are not distinguished by any uniform and explicit line from those of which the materials are wont to be carried to the head of property. A set of rights shall in one instant be considered as constituting an article of property rather than a condition, while in another instance a set of rights of the same stamp is considered as constituting rather a condition than an article of property. This will probably be found to be the case in all languages, and the usage is different again in one language from what it is in another. From these causes it seems to be impracticable to subject the class of civil conditions to any exhaustive method, so that for making a complete collection of them there seems to be no other expedient than that of searching the language through for them and taking them as they come. To exemplify this observation, it may be of use to lay open the structure, as it were, of 2 or 3 of the principal sorts or classes of conditions, comparing them with 2 or 3 articles of property which appear to be nearly of the same complexion. By this means the nature and generation, if one may so call it, of both these classes of ideal objects may be the more clearly understood. The several sorts of civil conditions that are not fiduciary may all, or at least the greater part of them, be comprehended under the head of rank, or that of profession, the latter word being taken in its most extensive sense, so as to include not only what are called the liberal professions, but those also which are exercised by the several sorts of traders, artists, manufacturers, and other persons of whatsoever station who are in the way of making a profit by their labour. Among ranks, then, as well as professions, let us, for the sake of perspicuity, take, for example, such articles as stand the clearest from any mixture of either fiduciary or beneficial power. The rank of knighthood is constituted how? By prohibiting all other persons from performing certain acts, the performance of which is the symbol of the order, at the same time that the knight in question and his companions are permitted, for instance, to wear a ribbon of a certain colour, in a certain manner, call himself by a certain title, to use an armorial seal with a certain mark on it. By laying all persons but the knight under this prohibition, the law subjects them to a set of duties, and since from the discharge of these duties a benefit results to the person in whose favour they are created, to wit, the benefit of enjoying such a share of extraordinary reputation as men are wont to yield to a person thus distinguished, to discharge them is to render him a service and duty, being a duty of the negative class, a duty consisting in the performance of certain acts of the negative kind. The service is what may be called a service of forbearance. It appears, then, that to generate this condition there must be two sorts of services: that which is the immediate cause of it, a service of the negative kind, to be rendered by the community at large; that which is the cause again of this service, a service of the positive kind, to be rendered by the law. The condition of a professional man stands upon a narrower footing. To constitute this condition there needs nothing more than a permission given him on the part of the legislator to perform those acts in the performance of which consists the exercise of his profession, to give or sell his advice or assistance in matters of law or physic, to give or sell his services as employed in the executing or overseeing of a manufacture or piece of work of such or such a kind, to sell a commodity of such or such a sort. Here then we see there is but one sort of service requisite, a service which may be merely of the negative kind, to be rendered by the law, the service of permitting him to exercise his profession, a service which, if there has been no prohibition laid on before, is rendered by simply forbearing to prohibit him. Now the ideal objects, which in the cases above specified are said to be conferred upon a man by the services that are respectively in question, are in both cases not articles of property, but conditions. By such a behaviour on the part of the law as shall be the reverse of that whereby they were respectively produced, a man may be made to forfeit them, and what he is then said to forfeit is in neither case his property, but in one case his rank or dignity, in the other case his trade or his profession, and in both cases his condition. Other cases there are again in which the law, by a process of the same sort with that by which it constituted the former of the two above-mentioned conditions, confers on him an ideal object, which the laws of language have placed under the head of property. The law permits a man to sell books, that is, all sorts of books in general. Thus far all that it has done is to invest him with a condition, and this condition he would equally possess, although every one else in the world were to sell book likewise. Let the law now take an active part in his favour, and prohibit all other persons from selling books of a certain description, he remaining at liberty to sell them as before. It therefore confers on him a sort of exclusive privilege or monopoly, which is called a copyright. But by investing him with this right, it is not said to invest him with any new sort of condition, What it invests him with is spoken of as an article of property, to wit, of that sort of property which is termed incorporeal, and so on in the case of an engraving, a mechanical engine, a medicine, or in short of a saleable article of any other sort. Yet when it gave him an exclusive right of wearing a particular sort of ribbon, the object which it then was considered as conferring on him was not an article of property, but a condition. By forbearing to subject you to certain disadvantages to which it subjects an alien, the law confers on you the condition of a natural-born subject. By subjecting him to them, it imposes on him the condition of an alien. By conferring on you certain privileges or rights, which it denies to roturiers, the law confers on you the condition of a gentilhomme. By forbearing to confer on him those privileges, it imposes on him the condition of a roturier. The rights out of which the two advantageous conditions here exemplified are both of them, as it were, composed, have for their counterpart a sort of service of forbearance, rendered, as we have seen, not by private individuals, but by the law itself. As to the duties which it creates in rendering you these services, they are to be considered as duties imposed by the legislator on the ministers of justice. It may be observed, with regard to the greater part of the conditions here comprised under the general appellation of civil, that the relations corresponding to those by which they are respectively constituted are not provided with appellatives. The relation which has a name is that which is borne by the party favoured to the party bound. That which is borne by the party bound to the party favoured has not any. This is a circumstance that may help to distinguish them from those conditions which we have termed domestic. In the domestic conditions, if on one side the party to whom the power is given is called a master, on the other side the party over whom the power is given, the party who is the object of that power, is termed a servant. In the civil conditions this is not the case. On the one side, a man, in virtue of certain services of forbearance which the rest of the community are bound to render him, is denominated a knight of such or such an order. But on the other side, these services do not bestow any particular denomination on the person for whom such services are due. Another man, in virtue of the legislator's rendering that sort of negative service which consists in the not prohibiting him from exercising a trade, invests him at his option with the condition of a trader. It accordingly denominates him a farmer, a baker, a weaver, and so on. But the ministers of the law do not, in virtue of their rendering this man this sort of negative service, acquire for themselves any particular name. Suppose even that the trade you have the right of exercising happens to be the object of a monopoly, and that the legislator, beside rendering you himself those services which you derive from the permission he bestows on you, obliges other persons to render you those farther services which you received from their forbearing to follow the same trade, yet neither do they, in virtue of their being thus bound, acquire any particular name. After what has been said of the nature of the several sorts of civil conditions that have names, the offences to which they are exposed may, without much difficulty, be imagined. Taken by itself, every condition which is thus constituted by a permission granted to the possessor is, of course, of a beneficial nature. It is therefore exposed to all those offences to which the possession of a benefit is exposed. But either on account of a man's being obliged to persevere when once engaged in it, or on account of such other obligations as may stand annexed to the possession of it, or on account of the comparative degree of disrepute which may stand annexed to it by the moral sanction, it may by accident be a burthen. It is on this account liable to stand exposed to the offences to which, as hath been seen, everything that partakes of the nature of a burthen stands exposed. As to any offences which may concern the exercise of the functions belonging to it, if it happens to have any duties annexed to it, such as those, for instance, which are constituted by regulations touching the exercise of a trade, It will stand exposed to so many breaches of duty, and lastly, whatsoever are the functions belonging to it, it will stand exposed at any rate to disturbance. In the forming, however, of the catalogue of these offences, exactness is of less consequence, insomuch as an act, if it should happen not to be comprised in this catalogue, and yet is in any respect of a pernicious nature, will be sure to be found in some other division of the system of offences. If a baker sells bad bread for the price of good, it is a kind of fraud upon the buyer, and perhaps an injury of the simple corporal kind done to the health of an individual or a neighbourhood. If a clothier sells bad cloth for good at home, it is a fraud. If to foreigners abroad, it may, over and above the fraud put upon the foreign purchaser, have pernicious effects, perhaps, in the prosperity of the trade at home, and become thereby an offence against the national wealth. So again with regard to disturbance. If a man be disturbed in the exercise of his trade, the offence will probably be a wrongful interception of the profit he might be presumed to have been in the way to make by it, and were it even to appear in any case that a man exercised a trade, or what is less unlikely, a liberal profession, without having profit in his view, the offence will still be reducible to the head of simple injurious restrainment, or simple injurious compulsion. End of chapter 16.
Chapter 16, paragraph 4 of An Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Anna Simon. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16, Division of Offences. Paragraph 4. Advantages of the present method. A few words for the purpose of giving a general view of the method of division here pursued, and of the advantages which it possesses, may have their use. The whole system of offences, we may observe, is branched out into 5 classes. In the 3 first, the subordinate divisions are taken from the same source, that is, from the consideration of the different points in respect whereof the interest of an individual is exposed to suffer. By this uniformity, a considerable degree of light seems to be thrown upon the whole system, particularly upon the offences that come under the 3rd class, objects which have never hitherto been brought into any sort of order. With regard to the 4th class, in settling the precedence between its several subordinate divisions, it seemed most natural and satisfactory to place those first, the connection whereof with the welfare of individuals seemed most obvious and immediate. The mischievous effects of those offences which tend in an immediate way to deprive individuals of the protection provided for them against the attacks of one another, and of those which tend to bring down upon them the attacks of foreign assailants, seem alike obvious and palpable. The mischievous quality of such as tend to weaken the force that is provided to combat those attacks, but particularly the latter, though evident enough, is one link farther off in the chain of causes and effects. The ill effects of such offences as are of disservice only by diminishing the particular fund from whence that force is to be extracted, such effects, I say, though indisputable, are still more distant and out of sight. The same thing may be observed with regard to such as are mischievous only by affecting the universal fund. Offences against the sovereignty in general would not be mischievous if offences of the several descriptions preceding were not mischievous. Nor in a temporal view are offences against religion mischievous, except in as far as, by removing, or weakening, or misapplying one of the 3 great incentives to virtue and checks to vice, they tend to open the door to several mischiefs, which it is the nature of all those other offences to produce. As to the 5th class, this, as hath already been observed, exhibits, at first view, an irregularity which however seems to be unavoidable. But this irregularity is presently corrected, when the analysis returns back, as it does after a step or two, into the path from which the tyranny of language had forced it a while to deviate. It was necessary that it should have 2 purposes in view: the one, to exhibit upon a scale more or less minute a systematical enumeration of the several possible modifications of delinquency, denominated or undenominated; The other, to find places in the list for such names of offences as were in current use. For the first purpose, nature was to set the law; for the other, custom. Had the nature of the things themselves been the only guide, every such difference in the manner of perpetration, and such only, should have served as a ground for a different denomination, as was attended with a difference in point of effect. This however of itself would never have been sufficient; for as on one hand the new language which it would have been necessary to invent would have been uncouth and in a manner unintelligible, so on the other hand the names which were before in current use, and which, in spite of all systems, good or bad, must have remained in current use, would have continued unexplained. To have adhered exclusively to the current language would have been as bad on the other side, for in that case the catalogue of offences, when compared to that of the mischiefs that are capable of being produced, would have been altogether broken and incomplete. To reconcile these two objects, in as far as they seem to be reconcilable, the following course has therefore been pursued. The logical whole, constituted by the sum total of possible offences, has been bisected in as many different directions as were necessary, and the process in each direction carried down to that stage at which the particular ideas thus divided found names in current use in readiness to receive them. At that period I have stopped, leaving any minuter distinctions to be enumerated in the body of the work, as so many species of the genus characterized by such or such a name. If in the course of any such process I came to a mode of conduct which, though it required to be taken notice of, and perhaps had actually been taken notice of, under all laws, in the character of an offence, had hitherto been expressed under different laws, by different circumlocutions, without ever having received any name capable of occupying the place of a substantive in a sentence, I have frequently ventured so far as to fabricate a new name for it, such a one as the idiom of the language and the acquaintance I happen to have with it would admit of; these names consisting in most instances, and that unavoidably, of two or three words brought together, in a language too which admits not, like the German and the Greek, of their being melted into one, can never be upon a par, in point of commodiousness, with those univocal appellatives which make part of the established stock. In the choice of names in current use, care has been taken to avoid all such as have been grounded on local distinctions, ill-founded perhaps in the nation in which they received their birth, and at any rate not applicable to the circumstances of other countries. The analysis, as far as it goes, is as applicable to the legal concerns of one country as of another, and where, if it had descended into further details, it would have ceased to be so, there I have taken care always to stop, and thence it is that it has come to be so much more particular in the class of offences against individuals than in any of the other classes. One use, then, of this arrangement, if it should be found to have been properly conducted, will be its serving to point out in what it is that the legal interests of all countries agree, and in what it is that they are liable to differ; how far a rule that is proper for one will serve and how far it will not serve for another. That the legal interests of different ages and countries have nothing in common, and that they have everything, are suppositions equally distant from the truth. A natural method, such as it hath been here attempted to exhibit, seems to possess four capital advantages, not to mention others of inferior note. In the first place, it affords such assistance to the apprehension and to the memory as those faculties would in vain look for in any technical arrangement. That arrangement of the objects of any science may, it should seem, be termed a natural one, which takes such properties to characterize them by, as men in general are, by the common constitution of man's nature, independently of any accidental impressions they may have received from the influence of any local or other particular causes, accustomed to attend to; such, in a word, as naturally, that is, readily and at first sight, engage and firmly fix the attention of any one to whom they have once been pointed out. Now, by what other means should an object engage or fix a man's attention, unless by interesting him? And what circumstance belonging to any action can be more interesting, or rather what other circumstance belonging to it can be at all interesting to him, than that of the influence it promises to have on his own happiness, and the happiness of those who are about him? By what other mark, then, should he more easily find the place which any offence occupies in the system, or by what other clue should he more readily recall it? In the next place, it not only gives at first glance a general intimation of the nature of each division of offences, in as far as that nature is determined by some one characteristic property, but it gives room for a number of general propositions to be formed concerning the particular offences that come under that division, in such manner as to exhibit a variety of other properties that may belong to them in common. It gives room, therefore, for the framing of a number of propositions concerning them, which, though very general, because predicated of a great number of articles, shall be as generally true. In the third place, it is so contrived that the very place which any offence is made to occupy suggests the reason of its being put there. It serves to indicate not only that such and such acts are made offences, but why they ought to be. By this means, while it addresses itself to the understanding, it recommends itself in some measure to the affections. By the intimation it gives of the nature and tendency of each obnoxious act, it accounts for, and in some measure vindicates, the treatment which it may be thought proper to bestow upon that act in the way of punishment. To the subject then it is a kind of perpetual apology, showing the necessity of every defalcation which, for the security and prosperity of each individual, it is requisite to make from the liberty of every other. To the legislator it is a kind of perpetual lesson, serving at once as a corrective to his prejudices and as a check upon his passions. Is there a mischief which has escaped him? In a natural arrangement, if at the same time an exhaustive one, he cannot fail to find it. Is he tempted ever to force innocence within the pale of guilt? The difficulty of finding a place for it advertises him of his error. Such are the uses of a map of universal delinquency, laid down upon the principle of utility. Such the advantages which the legislator as well as the subject may derive from it. Abide by it, and everything that is arbitrary in legislation vanishes. An evil-intentioned or prejudiced legislator dares not look it in the face. He would proscribe it, and with reason. It would be a satire on his laws. In the fourth place, a natural arrangement, governed as it is by a principle which is recognized by all men, will serve alike for the jurisprudence of all nations. In a system of proposed law, framed in pursuance of such a method, the language will serve as a glossary by which all systems of positive law might be explained, while the matter serves as a standard by which they might be tried. Thus illustrated, the practice of every nation might be a lesson to every other, and mankind might carry on a mutual interchange of experiences and improvements as easily in this as in every other walk of science. If any one of these objects should in any degree be attained, the labour of this analysis, severe as it has been, will not have been thrown away. End of Chapter 16, paragraph 4.
Chapter 16 of an Introduction to the Principles of Morals and Legislation. This is LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by May Lowe. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 16, Section 5. Characters of the Five Classes. It has been mentioned, as an advantage possessed by this method, and not possessed by any other, that the objects comprised under it are cast into groups, to which a variety of propositions may be applied in common. A collection of these propositions, as applied to the several classes, may be considered as exhibiting the distinctive characters of each class. So many of these propositions, as can be applied to the offences belonging to any given class, so many properties are they found to have in common. So many of these common properties as may respectively be attributed to them, so many properties may be set down to serve as characters of the class. A collection of these characters it may here be proper to exhibit. The more of them we can bring together, the more clearly and fully will the nature of the several classes and of the offences they are composed of be understood. Characters of Class 1, composed of private offences, or offences against assignable individuals. 1. When arrived at their last stage, the stage of consummation, they produce, all of them, a primary mischief as well as a secondary. 2. The individuals whom they affect in the first instance are constantly assignable. This extends to all, to attempts and preparations, as well as to such as have arrived at the stage of consummation. 3. Consequently, they admit of compensation, in which they differ from the offences of all the other classes as such. 4. They admit also of retaliation, in which they also differ from the offences of all the other classes. 5. There is always some person who has a natural and peculiar interest to prosecute them. In this they differ from self-regarding offences, also from semi-public and public ones, except in as far as the two latter may chance to involve a private mischief. 6. The mischief they produce is obvious, more so than that of semi-public offences, and still more so than that of self-regarding ones, or even public. 7. They are everywhere, and must ever be, obnoxious to the censure of the world, more so than semi-public offences as such, and still more so than public ones. 8. They are more constantly obnoxious to the censure of the world than self-regarding offences, and would be so universally, were it not for the influence of the two false principles, the principle of asceticism and the principle of antipathy. 9. They are less apt than the semi-public and public offences to require different descriptions in different states and countries, in which respect they are much upon a par with self-regarding ones. 10. By certain circumstances of aggravation, they are liable to be transformed into semi-public offences, and by certain others into public. 11. There can be no ground for punishing them until they can be proved to have occasioned, or to be about to occasion, some particular mischief to some particular individual. In this, they differ from semi-public offences and from public. 12. In slight cases, compensation given to the individual affected by them may be a sufficient ground for remitting punishment. For if the primary mischief has not been sufficient to produce any alarm, the whole of the mischief may be cured by compensation. In this also they differ from semi-public offences and from public ones. Characters of class 2, composed of semi-public offences, or offences affecting a whole subordinate class of persons. 1. As such, they produce no primary mischief. The mischief they produce consists of one or other or both branches of the secondary mischief produced by offences against individuals, without the primary. 2. In as far as they are able to be considered as belonging to this class, the persons whom they affect in the first instance are not individually assignable. 3. They are apt, however, to involve or terminate in some primary mischief of the first order, which when they do, they advance into the first class and become private offences. 4. They admit not, as such, of compensation. 5. Nor of retaliation. 6. As such, there is never any one particular individual whose exclusive interest it is to prosecute them. A circle of persons may, however, always be marked out, within which may be found some who have a greater interest to prosecute than any who are out of that circle have. 7. The mischief they produce is in general pretty obvious, not so much so indeed as that of private offences, but more so upon the whole than that of self-regarding and public ones. 8. They are rather less obnoxious to the censure of the world than private offences, but they are more so than public ones. They would also be more so than self-regarding ones, were it not for the influence of the two false principles, the principle of sympathy and antipathy, and that of asceticism. 9. They are more apt than private and self-regarding offences to require different descriptions in different countries, but less so than public ones. 10. There may be ground for punishing them before they have been proved to have occasioned, or be about to occasion, mischief to any particular individual, which is not the case with private offences. 11. In no cases can satisfaction given to any particular individual affected by them be a sufficient ground for remitting punishment, for by such satisfaction it is but a part of the mischief of them that is cured. In this they differ from private offences, but agree with public. Characters of class 3, consisting of self-regarding offences, offences against oneself. 1. In individual instances, it will often be questionable whether they are productive of any primary mischief at all. Secondary, they produce none. 2. They affect not any other individuals, assignable or non-assignable, except in as far as they affect the offender himself, unless by possibility in particular cases, and in a very slight and distant manner, the whole state. 3. They admit not, therefore, of compensation. 4. Nor of retaliation. 5. No person has naturally any peculiar interest to prosecute them, except in as far as in virtue of some connection he may have with the offender, either in point of sympathy or of interest, a mischief of the derivative kind may happen to devolve upon him. 6. The mischief they produce is apt to be unobvious and in general more questionable than that of any of the other classes. 7. They are, however, apt, many of them, to be more obnoxious to the censure of the world than public offences, owing to the influence of the two false principles, the principle of asceticism and the principle of antipathy. Some of them more even than semi-public or even than private offence. 8. They are less apt than offences of any other class to require different descriptions in different states and countries. 9. Among the inducements to punish them, antipathy against the offender is apt to have a greater share than sympathy for the public. 10. The best plea for punishing them is founded on a faint probability there may be, of their being productive of a mischief, which, if real, will place them in the class of public ones, chiefly in those divisions of it which are composed of offences against population and offences against national wealth. Characters of class 4, consisting of public offences, or offences against the state in general. 1. As such, they produce not any primary mischief, and the secondary mischief they produce, which consists frequently of danger without alarm, though great in value, is in specie very indeterminate. 2. The individuals whom they affect in the first instance are constantly unassignable, except in as far as by accident they happen to involve or terminate in such or such offences against individuals. 3. Consequently, they admit not of compensation. 4. Nor of retaliation. 5. Nor is there any person who has naturally any particular interest to prosecute them, except in as far as they appear to affect the power, or in any other manner the private interest, of some person in authority. 6. The mischief they produce, as such, is comparatively unobvious, much more so than that of private offences, and more so likewise than that of semi-public ones. 7. They are, as such, much less obnoxious to the censure of the world than private offences, less even than semi-public, or even than self-regarding offences, unless in particular cases, through sympathy to certain persons in authority, whose private interests they may appear to affect. 8. They are more apt than any of the other classes to admit of different descriptions in different states and countries. 9. They are constituted, in many cases, by some circumstances of aggravation superadded to a private offence, and therefore, in these cases, involve the mischief and exhibit the other characters belonging to both classes. They are, however, even in such cases, properly enough ranked in the fourth class inasmuch as the mischief they produce in virtue of the properties which aggregate them to that class, eclipses and swallows up that which they produce in virtue of those properties which aggregate them to the first. 10. There may be sufficient ground for punishing them, without their being proved to have occasioned, or to be about to occasion, any particular mischief to any particular individual. In this they differ from private offences, but agree with semi-public ones. Here, as in semi-public offences, the extent of the mischief makes up for the uncertainty of it. 11. In no case can satisfaction, given to any particular individual affected by them, be a sufficient ground for remitting punishment. In this they differ from private offences, but agree with semi-public. Characters of class 5, or appendix, composed of multiform or anomalous offences, and containing offences by falsehood and offences concerning trust. 1. Taken collectively, in the parcels marked out by their popular appellations, they are incapable of being aggregated to any systematical method of distribution grounded upon the mischief of the offence. 2. They may, however, be thrown into subdivisions, which may be aggregated to such a method of distribution. 3. These subdivisions will naturally and readily rank under the divisions of the several preceding classes of this system. 4. Each of the two great divisions of this class spreads itself in that manner over all the preceding classes. 5. In some acts of this class, the distinguishing circumstance, which constitutes the essential character of that offence, will, in some instances, enter necessarily, in the character of a criminative circumstance, into the constitution of the offence, insomuch that, without the intervention of this circumstance, no offence at all of that denomination can be committed. In other instances, the offence may subsist without it, and where it interferes, it comes in as an accidental independent circumstance, capable of constituting a ground of aggravation. End of chapter 16. Chapter 17 of an Introduction to the Principles of Morals and Legislation. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by May Lowe. An Introduction to the Principles of Morals and Legislation by Jeremy Bentham. Chapter 17 of the Limits of the Penal Branch of Jurisprudence. Section 1. Limits between private ethics and the art of legislation. So much for the division of offences in general. Now an offence is an act prohibited, or, what comes to the same thing, an act of which the contrary is commanded by the law. And what is it that the law can be employed in doing, besides prohibiting and commanding? It should seem, then, according to this view of the matter, that were we to have settled what may be proper to be done with relation to offences, we should thereby have settled everything that may be proper to be done in the way of law. Yet that branch which concerns the method of dealing with offences, and which is termed sometimes the criminal, sometimes the penal branch, is universally understood to be but one out of two branches which compose the whole subject of the art of legislation, that which is termed the civil being the other. Between these two branches, then, it is evident enough there cannot but be a very intimate connection. So intimate is it, indeed, that the limits between them are by no means easy to mark out. The case is the same in some degree between the whole business of legislation, civil and penal branches taken together, and that of private ethics. Of these several limits, however, it will be, in a manner, necessary to exhibit some idea, lest, on the one hand, we should seem to leave out any part of the subject that does belong to as untouched, or, on the other hand, to deviate on any side into a track which does not belong to us. In the course of this inquiry, that part of it, I mean, which concerns the limits between the civil and the penal branch of law, it will be necessary to settle a number of points, of which the connection with the main question might not at first sight be suspected. To ascertain what sort of a thing a law is, what the parts are that are to be found in it, what it must contain in order to be complete, what the connection is between that part of a body of laws which belongs to the subject of procedure and the rest of the law at large, all these, it will be seen, are so many problems which must be solved before any satisfactory answer can be given to the main question above mentioned. Nor is this their only use, for it is evident enough that the notion of a complete law must first be fixed before the legislator can, in any case, know what it is he has to do, or when his work is done. Ethics at large may be defined the art of directing men's actions to the production of the greatest possible quantity of happiness on the part of those whose interest is in view. What, then, are the actions which it can be in a man's power to direct? They must be either his own actions or those of other agents. Ethics, in as far as it is the art of directing a man's own actions, may be styled the art of self-government, or private ethics. What other agents, then, are there, which, at the same time that they are under the influence of man's direction, are susceptible of happiness? They are of two sorts. One, other human beings who are styled persons. Two, other animals, which, on account of their interests having been neglected by the insensibility of the ancient jurists, stand degraded into the class of things. As to other human beings, the art of directing their actions to the above end is what we mean, or at least the only thing which, upon the principle of utility, we ought to mean by the art of government, which, in as far as the measures it displays itself in are of a permanent nature, is generally distinguished by the name of legislation, as it is by that of administration when they are of a temporary nature, determined by the occurrences of the day. Now human creatures, considered with respect to the maturity of their faculties, are either in an adult or in a non-adult state. The art of government, in as far as it concerns the direction of the actions of persons in a non-adult state, may be termed the art of education. In as far as this business is entrusted with those who, in virtue of some private relationship, are in the main the best disposed to take upon them and the best able to discharge this office, it may be termed the art of private education. In as far as it is exercised by those whose province it is to superintend the conduct of the whole community, it may be termed the art of public education. As to ethics in general, a man's happiness will depend, in the first place, upon such parts of his behavior as none but himself are interested in; in the next place, upon such parts of it as may affect the happiness of those about him. In as far as his happiness depends upon the first mentioned part of his behavior, it is said to depend upon his duty to himself. Ethics, then, in as far as it is the art of directing a man's actions in this respect, may be termed the art of discharging one's duty to one's self, and the quality which a man manifests by the discharge of this branch of duty, if duty it is to be called, is that of prudence. In as far as his happiness, and that of any other person or persons whose interests are considered, depends upon such parts of his behavior as may affect the interests of those about him, it may be said to depend upon his duty to others, or, to use a phrase now somewhat antiquated, his duty to his neighbor. Ethics, then, in as far as it is the art of directing a man's actions in this respect, may be termed the art of discharging one's duty to one's neighbor. Now the happiness of one's neighbor may be consulted in two ways. One, in a negative way, by forbearing to diminish it. Two, in a positive way, by studying to increase it. A man's duty to his neighbour is accordingly partly negative and partly positive. To discharge the negative branch of it is probity. To discharge the positive branch, beneficence. It may here be asked, how is it that upon the principle of private ethics, legislation and religion out of the question, a man's happiness depends upon such parts of his conduct as affect, immediately at least, the happiness of no one but himself? This is as much to ask, what motives, independent of such as legislation and religion may chance to furnish, can one man have to consult the happiness of another, by what motives, or, which comes to the same thing, by what obligations can he be bound to obey the dictates of probity and beneficence? In answer to this, it cannot but be admitted that the only interests which a man at all times and upon all occasions is sure to find adequate motives for consulting are his own. Notwithstanding this, there are no occasions in which a man has not some motives for consulting the happiness of other men. In the first place, he has, on all occasions, the purely social motive of sympathy or benevolence. In the next place, he has, on most occasions, the semi-social motives of love of amity and love of reputation. The motive of sympathy will act upon him with more or less effect, according to the bias of his sensibility. The two other motives, according to a variety of circumstances, principally according to the strength of his intellectual powers, the firmness and steadiness of his mind, the quantum of his moral sensibility, and the characters of the people he has to deal with. Now private ethics has happiness for its end, and legislation can have no other. Private ethics concerns every member, that is, the happiness and actions of every member, of any community that can be proposed, and legislation can concern no more. Thus far, then, private ethics and the art of legislation go hand in hand. The end they have, or ought to have, in view, is of the same nature. The persons whose happiness they ought to have in view, as also the persons whose conduct they ought to be occupied in directing, are precisely the same. The very acts they ought to be conversant about are even in a great measure the same. Where then lies the difference? In that the acts which they ought to be conversant about, though in a great measure, are not perfectly and throughout the same. There is no case in which a private man ought not to direct his own conduct to the production of his own happiness, and that of his fellow creatures. But there are cases in which the legislator ought not, in a direct way at least, and by means of punishment applied immediately to particular individual acts, to attempt to direct the conduct of the several other members of the community. Every act which promises to be beneficial upon the whole to the community, himself included, each individual ought to perform of himself. But it is not every such act that the legislator ought to compel him to perform. Every act which promises to be pernicious upon the whole to the community, himself included, each individual ought to abstain from of him. But it is not every such act that the legislator ought to compel him to abstain from. Where then is the line to be drawn? We shall have not far to seek for it. The business is to give an idea of the cases in which ethics ought, and in which legislation ought not, in a direct manner at least, to interfere. If legislation interferes in a direct manner, it must be by punishment. Now the cases in which punishment, meaning the punishment of the political sanction, ought not to be inflicted, have been already stated. If then there be any of these cases in which, although legislation ought not, private ethics does or ought to interfere, these cases will serve to point out the limits between the two arts or branches of science. These cases, it may be remembered, are of four sorts: 1, where punishment would be groundless; 2, where it would be inefficacious; 3, where it would be unprofitable; 4, where it would be needless. Let us look over all these cases, and see whether in any of them there is room for the interference of private ethics, at the same time that there is none for the direct interference of legislation. 1. First, then, as to the cases where punishment would be groundless. In these cases it is evident that the restrictive interference of ethics would be groundless too. It is because, upon the whole, there is no evil in the act that legislation ought not to endeavour to prevent it. No more, for the same reason, ought private ethics. 2. As to the cases in which punishment would be inefficacious, these we may observe may be divided into two sets or classes. The first do not depend at all upon the nature of the act. They turn only upon a defect in the timing of the punishment. The punishment in question is no more than what, for anything that appears, ought to have been applied to the act in question. It ought, however, to have been applied at a different time. Videlicet, not till after it had been properly denounced. These are cases of an ex post facto law, of a judicial sentence beyond the law, and of a law not sufficiently promulgated. The acts here in question then might, for anything that appears, come properly under the department even of coercive legislation. Of course do they under that of private ethics. As to the other set of cases in which punishment would be inefficacious, neither do these depend upon the nature of the act, that is, the sort of act, they turn only upon some extraneous circumstances with which an act of any sort may chance to be accompanied. These, however, are of such a nature as not only to exclude the application of legal punishment, but in general to leave little room for the influence of private ethics. These are the cases where the will could not be deterred from any act, even by the extraordinary force of artificial punishment, as in the cases of extreme infancy, insanity, and perfect intoxication. Of course, therefore, it could not by such slender and precarious force as could be applied by private ethics. The case is in this respect the same, under the circumstances of unintentionality, with respect to the event of the action, unconsciousness with regard to the circumstances, and missupposal with regard to the existence of circumstances which have not existed, as also where the force, even of extraordinary punishment, is rendered inoperative by the superior force of a physical danger or threatened mischief. It is evident that in these cases, if the thunders of the law prove impotent, the whispers of simple morality can have but little influence. 3. As to the cases where punishment would be unprofitable. These are the cases which constitute the great field for the exclusive interference of private ethics. When a punishment is unprofitable, or in other words too expensive, it is because the evil of the punishment exceeds that of the offence. Now the evil of the punishment, we may remember, is distinguishable into four branches. 1. The evil of coercion, including constraint or restraint, according as the act commanded is of the positive kind or the negative. 2. The evil of apprehension. 3. The evil of sufferance. 4. The derivative evils resulting to persons in connection with those by whom the three above-mentioned original evils are sustained. Now with respect to those original evils, the persons who lie exposed to them may be two very different sets of persons. In the first place, persons who may have actually committed or been prompted to commit the acts really meant to be prohibited. In the next place, persons who may have performed or been prompted to perform such other acts as they fear may be in danger of being involved in the punishment designed only for the former. But of these two sets of acts, it is the former only that are pernicious. It is, therefore, the former only that it can be the business of private ethics to endeavour to prevent. The latter, being by the supposition not mischievous, to prevent them is what it can no more be the business of ethics to endeavour at than of legislation. It remains to show how it may happen that there should be acts really pernicious, which, although they may very properly come under the censure of private ethics, may yet be no fit objects for the legislator to control. Punishment, then, as applied to delinquency, may be unprofitable in both or either of two ways. 1. By the expense it would amount to, even supposing the application of it to be confined altogether to delinquency. 2. By the danger there may be of its involving the innocent in the fate designed only for the guilty. First, then, with regard to the cases in which the expense of the punishment, as applied to the guilty, would outweigh the profit to be made by it. These cases, it is evident, depend upon a certain proportion between the evil of the punishment and the evil of the offence. Now were the offence of such a nature that a punishment which, in point of magnitude, should but just exceed the profit of it, would be sufficient to prevent it, it might be rather difficult, perhaps, to find an instance in which such punishment would clearly appear to be unprofitable. But the fact is, that there are many cases in which a punishment, in order to have any chance of being efficacious, must, in point of magnitude, be raised a great deal above that level. Thus it is, wherever the danger of detection is, or, what comes to the same thing, is likely to appear to be so small as to make the punishment appear in a high degree uncertain. In this case, it is necessary, as has been shown, if punishment be at all applied, to raise it in point of magnitude as much as it falls short in point of certainty. It is evident, however, that all this can be but guesswork, and that the effect of such a proportion will be rendered precarious by a variety of circumstances. By the want of sufficient promulgation on the part of the law, by the particular circumstances of the temptation, and by the circumstances influencing the sensibility of the several individuals who are exposed to it. Let the seducing motives be strong, the offence, then, will at any rate be frequently committed. Now and then, indeed, owing to a coincidence of circumstances more or less extraordinary, it will be detected, and by that means punished. But for the purpose of example, which is the principal one, an act of punishment considered in itself is of no use. What use it can be of depends altogether upon the expectation it raises of similar punishment in future cases of similar delinquency. But this future punishment, it is evident, must always depend upon detection. If, then, the want of detection is such as must in general, especially to eyes fascinated by the force of the seducing motives, appear too improbable to be reckoned upon, the punishment, though it should be inflicted, may come to be of no use. Here, then, will be two opposite evils running on at the same time, yet neither of them reducing the quantum of the other, the evil of the disease and the evil of the painful and inefficacious remedy. It seems to be partly owing to some such considerations that fornication, for example, or the illicit commerce between the sexes, has commonly either gone altogether unpunished, or been punished in a degree inferior to that in which, on other accounts, legislators might have been disposed to punish it. Secondly, with regard to the cases in which political punishment, as applied to delinquency, may be unprofitable, in virtue of the danger that there may be of its involving the innocent in the fate designed only for the guilty. Whence should this danger then arise? From the difficulty there may be of fixing the idea of the guilty action, that is, of subjecting it to such a definition as shall be clear and precise enough to guard effectively against misapplication. This difficulty may arise from either of two sources, the one permanent, to wit, the nature of the actions themselves, the other occasional, I mean the qualities of the men who may have to deal with those actions in the way of government. In as far as it arises from the latter of these sources, it may depend partly upon the use which the legislator may be able to make of language, partly upon the use which, according to the apprehension of the legislators, the judge may be disposed to make of it. As far as legislation is concerned, it will depend upon the degree of perfecting to which the arts of language may have been carried, in the first place, in the nation in general, in the next place, by the legislator in particular. It is to a sense of this difficulty, as it should seem, that we may attribute the caution with which most legislators have abstained from subjecting to censure, on the part of the law, such actions as come under the notion of rudeness, for example, or treachery, or ingratitude. The attempt to bring acts of so vague and questionable a nature under the control of law will argue either a very immature age, in which the difficulties which give birth to that danger are not described, or a very enlightened age, in which they are overcome. For the sake of obtaining the clearer idea of the limits between the art of legislation and private ethics, it may now be time to call to mind the distinctions above established with regard to ethics in general. The degree in which private ethics stands in need of the assistance of legislation is different in the three branches of duty above distinguished. Of the rules of moral duty, those which seem to stand least in need of the assistance of legislation are the rules of prudence. It can only be through some defect on the part of the understanding if a man be ever deficient in point of duty to himself. If he does wrong, there is nothing else that it can be owing to but either some inadvertence or some missupposal with regard to the circumstances on which his happiness depends. It is a standing topic of complaint that a man knows too little of himself. Be it so, but is it so certain that the legislator must know more? It is plain that of individuals the legislator can know nothing. Concerning those points of conduct which depend upon the particular circumstances of each individual, it is plain, therefore, that he can determine nothing to advantage. It is only with respect to those broad lines of conduct in which all persons, or very large and permanent descriptions of persons, may be in a way to engage, that he can have any pretence for interfering. And even here, the propriety of his interference will, in most circumstances, lie very open to dispute. At any rate, he must never expect to produce a perfect compliance by the mere force of the sanction of which he is himself the author. All he can hope to do is to increase the efficacy of private ethics by giving strength and direction to the influence of the moral sanction. With what chance of success, for example, would a legislator go about to extirpate drunkenness and fornication by dint of legal punishment? Not all the tortures which ingenuity could invent would compass it, and, before he had made any progress worth regarding, such a mass of evil would be produced by the punishment as would exceed 1,000-fold the utmost possible mischief of the offence. The great difficulty would be in procuring evidence, an object which could not be attempted with any probability of success, without spreading dismay through every family, tearing the bonds of sympathy asunder, and rooting out the influence of all the social motives. All he can do, then, against offences of this nature, with any prospect of advantage in the way of direct legislation, is to subject them, in cases of notoriety, to a slight censure, so as to thereby cover them with a slight shade of artificial disrepute. It may be observed that with regard to this branch of duty, legislators have, in general, been disposed to carry their interference full as far as is expedient. The great difficulty here is to persuade them to confine themselves within bounds. 1,000 little passions and prejudices have led them to narrow the liberty of the subject in this line, in cases in which the punishment is either attended with no profit at all, or with none that will make up for the expense. The mischief of this sort of interference is more particularly conspicuous in the article of religion. The reasoning in this case is of the following stamp. There are certain errors, in matters of belief, to which all mankind are prone, and for these errors in judgment, it is the determination of a being of infinite benevolence to punish them with an infinity of torments. But from these errors the legislator himself is necessarily free, for the men who happen to be at hand for him to consult with, being men perfectly enlightened, unfettered, and unbiased, have such advantages over all the rest of the world, that when they sit down to inquire out the truth relative to points so plain and so familiar as those in question, they cannot fail to find it. This being the case, when the sovereign sees his people ready to plunge headlong into an abyss of fire, shall he not stretch out a hand to save them? Such, for example, seems to have been the train of reasoning, and such the motives, which led Louis XIV. Into those coercive measures which he took for the conversion of heretics and the confirmation of true believers. The groundwork, pure sympathy and loving kindness; the superstructure, all the miseries which the most determined malevolence could have devised. But of this more fully in another place. The rules of probity are those which in point of expediency stand most in need of assistance on the part of the legislator, and in which, in point of fact, his interference has been most extensive. There are few cases in which it would be expedient to punish a man for hurting himself, but there are few cases, if any, in which it would not be expedient to punish a man for injuring his neighbor. With regard to that branch of probity which is opposed to offences against property, private ethics depends in a manner for its very existence upon legislation. Legislation must first determine what things are to be regarded as each man's property, before the general rule of ethics on this head can have any particular application. The case is the same with regard to offences against the state. Without legislation, there would be no such thing as a state, no particular persons invested with powers to be exercised for the benefit of the rest. It is plain, therefore, that in this branch the interference of the legislator cannot anywhere be dispensed with. We must first know what are the dictates of legislation before we can know what are the dictates of private ethics. As to the rules of beneficence, these, as far as concerns matters of detail, must necessarily be abandoned in great measure to the jurisdiction of private ethics. In many cases, the beneficial quality of the act depends essentially upon the disposition of the agent, that is, upon the motive by which he appears to have been prompted to perform it, upon their belonging to the head of sympathy, love of amity, or love of reputation, and not to any head of self-regarding motives brought into play by the force of political constraint; in a word, upon their being such as denominate his conduct free and voluntary, according to one of the many senses given to those ambiguous expressions. The limits of the law on this head seem, however, to be capable of being extended a good deal farther than they seem ever to have been extended hitherto. In particular, in cases where the person is in danger, why should it not be made the duty of every man to save another from mischief, when it can be done without prejudicing himself, as well as to abstain from bringing it on him? This, accordingly, is the idea pursued in the body of the work. To conclude this section, let us recapitulate, and bring to a point the difference between private ethics, considered as an art or science, on the one hand, and that branch of jurisprudence which contains the art or science of legislation on the other. Private ethics teaches how each man may dispose himself to pursue the course most conducive to his own happiness, by means of such motives as offer of themselves. The art of legislation, which may be considered as one branch of the science of jurisprudence, teaches how a multitude of men, composing a community, may be disposed to pursue that course which upon the whole is the most conducive to the happiness of the whole community, by means of motives to be applied by the legislator. We come now to exhibit the limits between penal and civil jurisprudence. For this purpose it may be of use to give a distinct though summary view of the principal branches into which jurisprudence, considered in its utmost extent, is wont to be divided. Section 2. Jurisprudence, its branches. Jurisprudence is a fictitious entity, nor can any meaning be found for the word but by placing it in company with some word that shall be significative of a real entity. To know what is meant by jurisprudence, we must know, for example, what is meant by a book of jurisprudence. A book of jurisprudence can have but one or the other of two objects: 1, to ascertain what the law is; 2, to ascertain what it ought to be. In the former case, it may be styled a book of expository jurisprudence, in the latter, a book of censorial jurisprudence, or, in other words, a book on the art of legislation. A book of expository jurisprudence is either authoritative or unauthoritative. It is styled authoritative when it is composed by him who, by representing the state of the law to be so and so, causeth it so to be, that is, of the legislator himself; unauthoritative when it is the work of any other person at large. Now law, or the law, taken indefinitely, is an abstract and collective term, which, when it means anything, can mean neither more nor less than the sum total of a number of individual laws taken together. It follows that of whatever other modifications the subject of a book of jurisprudence is susceptible, they must all of them be taken from some circumstance or other of which such individual laws or the assemblages into which they may be sorted are susceptible. The circumstances that have given rise to the principal branches of jurisprudence we are wont to hear of seem to be as follows: 1. The extent of the laws in question in point of dominion. 2. The political quality of the persons whose conduct they undertake to regulate. 3. The time of their being in force. 4. The manner in which they are expressed. 5. The concern which they have with the article of punishment. In the first place, in point of extent, what is delivered concerning the laws in question may have reference either to the laws of such and such a nation or nations in particular, or to the laws of all nations whatsoever. In the first case, the book may be said to relate to local, in the other to universal jurisprudence. Now of the infinite variety of nations there are upon the earth, there are no two which agree exactly in their laws, certainly not in the whole, perhaps not even in any single article, and let them agree today, they would disagree tomorrow. This is evident enough with regard to the substance of the laws, and it would still be more extraordinary if they agreed in point of form, that is, if they were conceived in precisely the same strings of words. What is more, as the languages of nations are commonly different as well as their laws, it is seldom that, strictly speaking, they have so much as a single word in common. However, among the words that are appropriated to the subject of law, there are some that in all languages are pretty exactly correspondent to one another, which comes to the same thing nearly as if they were the same. Of this stamp, for example, are those which correspond to the words power, right, obligation, liberty, and many others. It follows that if there are any books which can, properly speaking, be styled books of universal jurisprudence, they must be looked for within very narrow limits. Among such as are expository, there can be none that are authoritative, nor even, as far as the substance of the laws is concerned, any that are unauthoritative. To be susceptible of an universal application, all that a book of the expository kind can have to treat of is the import of words. To be, strictly speaking, universal, it must confine itself to terminology. Accordingly, the definitions which there has been occasion here and there to intersperse in the course of the present work, and particularly the definition hereafter given to the word law, may be considered as matter belonging to the head of universal jurisprudence. Thus far in strictness of speech, though in point of usage where a man, in laying down what he apprehends to be the law, extends his view to a few of the nations with which his own is most connected, it is common enough to consider what he writes as relating to universal jurisprudence. It is in the censorial line that there is the greatest room for disquisitions that apply to the circumstances of all nations alike, and in this line, what regards the substance of the laws in question is as susceptible of an universal application as what regards the words. That the laws of all nations, or even of any two nations, should coincide in all points, would be as ineligible as it is impossible. Some leading points, however, there seem to be, in respect of which the laws of all civilized nations might, without inconvenience, be the same. To mark out some of these points will, as far as it goes, be the business of the body of this work. In the second place, with regard to the political quality, of the persons whose conduct is the object of the law. These may, on any given occasion, be considered as either members of the same state or as members of different states. In the first case, the law may be referred to the head of internal, in the second case, to that of international jurisprudence. Now as to any transactions which may take place between individuals who are subjects of different states, these are regulated by internal laws, and decided upon by the internal tribunals of the one or the other of those states. The case is the same where the sovereign of the one has any immediate transactions with a private member of the other, the sovereign reducing himself, pro re nata, to the condition of a private person, as often as he submits his cause to either tribunal, whether by claiming a benefit or defending himself against a burden. There remain then the mutual transactions between sovereigns, as such, for the subject of that branch of jurisprudence which may be properly and exclusively termed international. With what degree of propriety rules for the conduct of persons of this description can come under the appellation of laws, is a question that must rest till the nature of the thing called a law shall have been more particularly unfolded. It is evident enough that international jurisprudence may, as well as internal, be censorial as well as expository, unauthoritative as well as authoritative. Internal jurisprudence, again, may either concern all the members of a state indiscriminately, or such of them as are connected in the way of residence or otherwise with a particular district. Jurisprudence is accordingly sometimes distinguished into national and provincial, but as the epithet provincial is hardly applicable to a district so small as many of those which have laws of their own are wont to be, such as towns, parishes, and manors, the term local, where universal jurisprudence is plainly out of the question, or the term particular, though this latter is not very characteristic, might either of them be more commodious. Thirdly, with respect to time. In a work of the expository kind, the laws that are in question may either be such as are still in force at the time when the book is writing, or such as have ceased to be in force. In the latter case, the subject of it might be termed ancient, in the former, present or living jurisprudence. That is, if the substantive jurisprudence, and no other, must at any rate be employed, and that with an epithet in both cases. But the truth is, that a book of the former kind is rather a book of history than a book of jurisprudence, and if the word jurisprudence be expressive of the subject, it is only with some such words as history or antiquities prefixed. And as the laws which are anywhere in question are supposed, if nothing appears to the contrary, to be those which are in force, no such epithet as that of present or living commonly appears. Where a book is so circumstanced that the laws from which the subject of it, though in force at the time of its being written, are in force no longer, that book is neither a book of living jurisprudence nor a book on the history of jurisprudence. It is no longer the former, and it was never the latter. It is evident that, owing to the changes which from time to time must take place, in a greater or less degree, in every body of laws, every book of jurisprudence, which is of an expository nature, must in the course of a few years come to partake more or less of this condition. The most common and most useful object of a history of jurisprudence is to exhibit the circumstances that have attended the establishment of laws actually in force, but the exposition of the dead laws which have been superseded is inseparably interwoven with that of the living ones which have superseded them. The great use of both these branches of science is to furnish examples for the art of legislation. Fourthly, in point of expression, the laws in question may subsist either in the form of statute or in that of customary law. As to the difference between these two branches, which respects only the article of form or expression, it cannot properly be made appear till some progress has been made in the definition of a law. Lastly, the most intricate distinction of all, and that which comes most frequently on the carpet, is that which is made between the civil branch of jurisprudence and the penal, which latter is wont, in certain circumstances, to receive the name of criminal. What is a penal code of laws? What is a civil code? Of what nature are their contents? Is it that there are two sorts of laws, the one penal, the other civil, so that the laws in a penal code are all penal laws, while the laws in a civil code are all civil laws? Or is it that in every law there is some matter which is of a penal nature, and which therefore belongs to the penal code, and at the same time other matter which is of a civil nature, and which therefore belongs to the civil code? Or is it that some laws belong to one code or the other exclusively, while others are divided between the two? To answer these questions in any manner that shall be tolerably satisfactory, it will be necessary to ascertain what a law is, meaning one entire but single law, and what are the parts into which a law, as such, is capable of being distinguished, or, in other words, to ascertain what the properties are that are to be found in every object which can with propriety receive the appellation of a law. This, then, will be the business of the third and fourth sections. What concerns the import of the word criminal, as applied to law, will be discussed separately in the fifth. Footnote 27. Here ends the original work, in the state into which it was brought in 5 November 1780. What follows is now added in January 1789. The third, fourth, and fifth sections intended, as expressed in the text, to have been added to this chapter, will not here nor now be given, because to give them in a manner tolerably complete and satisfactory might require a considerable volume. This volume will form a work of itself, closing the series of works mentioned in the preface. What follows here may serve to give a slight intimation of the nature of the task which such a work will have to achieve. It will at the same time furnish, not anything like a satisfactory answer to the questions mentioned in the text, but a slight and general indication of the course to be taken for giving them such an answer. What is a law? What are the parts of a law? The subject of these questions, it is to be observed, is the logical, the ideal, the intellectual whole, not the physical one, the law and not the statute. An enquiry directed to the latter sort of object could neither admit of difficulty nor afford instruction. In this sense, whatever is given for law, by the person or persons recognized as possessing the power of making laws, is law. The metamorphoses of Ovid, if thus given, would be law. So much as was embraced by one and the same act of authentication, so much as received the touch of the sceptre at one stroke, is one law, a whole law and nothing more. A statute of George II, made to substitute an or instead of an and in a former statute, is a complete law. A statute containing an entire body of laws, perfect in all its parts, would not be more so. By the word law, then, as often as it occurs in the succeeding pages, is meant that ideal object, of which the part, the whole, or the multiple, or an assemblage of parts, wholes, and multiples mixed together, is exhibited by a statute, not the statute which exhibits them. Every law, when complete, is either of a coercive or an uncoercive nature. A coercive law is a command. An uncoercive, or rather a discoercive law, is the revocation, in whole or in part, of a coercive law. What has been termed declaratory law, so far as it stands distinguished from either a coercive or discoercive law, is not properly speaking a law. It is not the expression of an act, of the will exercised at the time. It is a mere notification of the existence of a law, either of the coercive or the discoercive kind, as already subsisting, of the existence of some document expressive of some act of the will, exercised not at the time, but at some former period. If it does anything more than give information of this fact, viz. of the prior existence of a law of either the coercive or the discoercive kind, it ceases pro tanto to be what is meant by a declaratory law, and assuming either the coercive or the discoercive quality. Every coercive law creates an offence, that is, converts an act of some sort or other into an offence. It is only by doing so that it can impose obligation, that it can produce coercion. A law confining itself to the creation of an offence, and a law commanding a punishment to be administered in the case of the commission of such an offence, are two distinct laws, not parts, as they seem to have been generally accounted hitherto, of one and the same law. The acts they command are altogether different. The persons they are addressed to are altogether different. Instance: let no man steal, and let the judge cause whoever is convicted of stealing to be hanged. They might be styled, the former, a simply imperative law, the other a punitory. But the punitory, if it commands the punishment to be inflicted, and does not merely permit it, is as truly imperative as the other, only it is punitory besides, which the other is not. A law of the discoercive kind, considered in itself, can have no punitory law belonging to it. To receive the assistance and support of a punitory in law, it must first receive that of a simply imperative or coercive law, and it is to this latter that the punitory law will attach itself, and not to the discoercive one. Example: discoercive law. The sheriff has the power to hang all such as the judge, proceeding in due course of law, shall order him to hang. Example of a coercive law made in support of the above discoercive one: let no man hinder the sheriff from hanging such as the judge, proceeding in due course of law, shall order him to hang. Example of a punitory law made in support of the above coercive one: let the judge cause to be imprisoned whosoever attempts to hinder the sheriff from hanging one whom the judge proceeding in due course of law has ordered him to hang. But though a simply imperative law and the punitory law attached to it are so far distinct laws that the former contains nothing of the latter, and the latter, in its direct tenor, contains nothing of the former, yet by implication, and that a necessary one, the punitory does not involve and include the import of the simply imperative law to which it is appended. To say to the judge, cause to be hanged whoever in due form of law is convicted of stealing, is, though not a direct, yet as intelligible a way of intimating to men in general that they must not steal, as to say to them directly, do not steal. And one sees how much more likely to be efficacious. It should not seem, then, that wherever a simply imperative law is to have a punitory one appended to it, the former might be spared altogether. In which case, saving the exception, which naturally should seem not likely to be a frequent one, of a law capable of answering its purpose without such an appendage, there should be no occasion in the whole body of the law for any other than punitory, or in other words, than penal laws. And this perhaps would be the case, were it not for the necessity of a large quantity of matter of the expository kind, of which we come now to speak. It will happen in the instance of many, probably of most, possibly of all, commands endued with the force of a public law, that, in the expression given to such a command, it shall be necessary to have recourse to terms too complex in their signification to exhibit the requisite ideas, without the assistance of a greater or less quantity of matter of an expository nature. Such terms, like the symbols used in algebraical notation, are rather substitutes and indexes to the terms capable of themselves of exhibiting the ideas in question, than the real and immediate representatives of those ideas. Take, for instance, the law, "Thou shalt not steal." Such a command, were it to rest there, could never sufficiently answer the purpose of a law. A word of so vague and unexplicit a meaning cannot otherwise perform this office than by giving a general intimation of a variety of propositions, each requiring, to convey it to the apprehension, a more particular and ample assemblage of terms. Stealing, for example, according to a definition not accurate enough for use, but sufficiently so for the present purpose, is the taking of a thing which is another's by one who has no title so to do, and is conscious of his having none. Even after this exposition, supposing it a correct one, can the law be regarded as completely expressed? Certainly not. For what is meant by a man's having a title to take a thing? To be complete, the law must have exhibited, amongst a multitude of other things, two catalogues, the one of events to which it has given the quality of conferring title in such a case, the other of the events to which it has given the quality of taking it away. What follows? That for a man to have stolen, for a man to have had no title to what he took, either no one of the articles contained in the first of those lists must have happened in his favour, or, if there has, some one of the number of those contained in the second must have happened to his prejudice. Such then is the nature of a general law, that while the imperative part of it, the punctum saliens, as it may be termed, of this artificial body, shall not take up above 2 or 3 words, its expository appendage, without which that imperative part could not rightly perform its office, may occupy a considerable volume. But this may equally be the case with a private order given in a family. Take, for instance, one from a bookseller to his foreman. Remove from this shop to my new one my whole stock according to this printed catalogue. Remove from this shop to my new one my whole stock, is the imperative matter of this order. The catalogue referred to contains the expository appendage. The same mass of expository matter may serve in common for, may appertain in common to, many commands, many masses of imperative matter. Thus, amongst other things, the catalogue of collative and ablative events, with respect to titles above spoken of, will belong in common to all or most of the laws constitutive of the various offences against property. Thus, in mathematical diagrams, one and the same base shall serve for a whole cluster of triangles. Such expository matter, being of a complexion so different from the imperative, it would be no wonder if the connection of the former with the latter should escape the observation, which indeed is perhaps pretty generally the case. And so long as any mass of legislative matter presents itself, which is not itself imperative or the contrary, or of which the connection with matter of one of those two descriptions is not apprehended, so long and so far the truth of the proposition that every law is a command or its opposite may remain unsuspected or appear questionable. So long also may the incompleteness of the greater part of those masses of legislative matter which wear the complexion of complete laws upon the face of them, also the method to be taken for rendering them really complete, remain undiscovered. A circumstance that will naturally contribute to increase the difficulty of the discovery is the great variety of ways in which the imperation of a law may be conveyed, the great variety of forms which the imperative part of a law may indiscriminately assume, some more directly, some less directly expressive of the imperative quality. Thou shalt not steal. Let no man steal. Whoso stealeth shall be punished so and so. If any man steal, he shall be punished so and so. Stealing is where a man does so and so. The punishment for stealing is so and so. To judges, so and so named, and so constituted, belong the cognizance of such and such offences, videlicet stealing, and so on. These are but part of a multitude of forms of words, in any of which the command by which stealing is prohibited might equally be couched, and it is manifest to what a degree in some of them the imperative quality is clouded and concealed from ordinary apprehension. After this explanation, a general proposition or two that may be laid down may help to afford some little insight into the structure and contents of a complete body of laws. So many different sorts of offences created, so many different laws of the coercive kind, so many exceptions taken out of the descriptions of those offences, so many laws of the discoercive kind. To class offences, as hath been attempted to be done in the preceding chapter, it is therefore to class laws. To exhibit a complete catalogue of all the offences created by law including the whole mass of expository matter necessary for fixing and exhibiting the import of the terms contained in the several laws, by which those offences are respectively created, would be to exhibit a complete collection of the laws in force, in a word, a complete body of law, a panomion, if so it might be termed. From the obscurity in which the limits of a law, and the distinction betwixt a law of the civil or simply imperative kind and a punitory law of are naturally involved, results the obscurity of the limits betwixt a civil and a penal code, betwixt a civil branch of the law and the penal. The question, what parts of the total mass of legislative matter belong to the civil branch and what to the penal, supposes that diverse political states, or at least that some one such state, are to be found, having as well a civil code as a penal code, each of them complete in its kind and marked out by certain limits. But no one such state has ever yet existed. To put a question to which a true answer can be given, we must substitute the foregoing question some such a one as that which follows. Suppose two masses of legislative matter be drawn up at this time of day, the one under the name of a civil code, the other of a penal code, each meant to be complete in its kind. In what general way is it natural to suppose that the different sorts of matter as above distinguished would be distributed between them? To this question the following answer seems likely to come as near as any other to the truth. The civil code would not consist of a collection of civil laws, each complete in itself, as well as clear of all penal ones. Neither would the penal code, since we have seen that it could not, consist of a collection of punitive laws, each not only complete in itself, but clear of all civil ones. But the civil code would consist chiefly of mere masses of expository matter. The imperative matter, to which those masses of expository matter respectively appertained, would be found, not in that same code, not in the civil code, nor in a pure state free from all admixture of punitory laws, but in the penal code, in a state of combination, involved, in manner as above explained, in so many correspondent punitory laws. The penal code, then, would consist principally of punitive laws, involving the imperative matter of the whole number of civil laws, along with which would probably also be found various masses of expository matter, appertaining not to the civil, but to the punitory laws. The body of penal law enacted by Empress Queen Maria Theresa agrees pretty well with this account. The mass of legislative matter published in French as well as German under the auspices of Frederick II. Of Prussia, by the name of Code Frederick, but never established with force of law, appears, for example, to be almost wholly composed of masses of expository matter, the relation of which to any imperative matter appears to have been but very imperfectly apprehended. In that enormous mass of confusion and inconsistency, the ancient Roman, or, as it is termed by way of eminence, the civil law, the imperative matter, and even all traces of the imperative character, seem at last to have been smothered in the expository. Esto had been the language of primeval simplicity. Esto had been the language of the 12 tables. By the time of Justinian, so thick was the darkness raised by clouds of commentators, the penal law had been crammed into an odd corner of the civil. The whole catalogue of offences, and even of crimes, lay buried under a heap of obligations. Will was hid in opinion, and the original esto had transformed itself into videtur in the mouths of even the most despotic sovereigns. Among the barbarous nations that grew up out of the ruins of the Roman Empire, law, emerging from under the mountain of expository rubbish, reassumed for a while the language of command, and then she had simplicity at least, if nothing else, to recommend her. Besides the civil and the penal, every complete body of law must contain a third branch, the constitutional. The constitutional branch is chiefly employed in conferring, on particular classes of persons, powers, to be exercised for the good of the whole society, or of considerable parts of it, and prescribing duties to the persons invested with those powers. The powers are principally constituted in the first instance by discoercive or permissive laws, operating as exceptions to certain laws of the coercive or imperative kind. Instance: a tax gatherer, as such, may, on such and such an occasion, take such and such things without any other title. The duties are created by imperative laws, addressed to the persons on whom the powers are conferred. Instance: on such and such an occasion, such and such a tax gatherer shall take such and such things. Such and such a judge shall, in such and such a case, cause persons so and so offending to be hanged. The parts which perform the function of indicating who the individuals are, who, in every case, shall be considered as belonging to those classes, have neither a permissive complexion nor an imperative. They are so many masses of expository matter, appertaining in common to all laws, into the texture of which the names of those classes of persons have occasion to be inserted. Instance: imperative matter. Let the judge cause whoever, in due course of law, is convicted of stealing, to be hanged. Nature of the expository matter. Who is the person meant by the word judge? He who has been invested with that office in such a manner, and in respect of whom no event has happened, of the number of those to which the effect is given, of reducing him to the condition of one divested of that office. Thus it is that one and the same law, one and the same command, will have its matter divided, not only between the two great codes, or main branches of the whole body of the laws, the civil and the penal, but amongst three such branches, the civil, the penal, and the constitutional. In countries where a great part of the law exists in no other shape than that of which in England is called common law, but might be more expressively termed judiciary, there must be a great multitude of laws, the import of which cannot be sufficiently made out for practice, without referring to this common law for more or less the expository matter belonging to them. Thus in England, the exposition of the word title, that basis of the whole fabric of the laws of property, is nowhere else to be found. And as uncertainty is of the very essence of every particle of law so denominated, for the instant it is clothed in a certain authoritative form of words it changes its nature and passes over to the other denomination. Hence it is that a great part of the laws in being in such countries remain uncertain and incomplete. What are those countries? To this hour, every one on the surface of the globe. Had the science of architecture no fixed nomenclature belonging to it, were there no settled names for distinguishing the different sorts of buildings, nor the different parts of the same building from each other, what would it be? It would be what the science of legislation, considered with respect to its form, remains at present. Were there no architects who could distinguish a dwelling house from a barn, or a side wall from a ceiling, what would architects be? They would be what all legislators are at present. From this very slight and imperfect sketch may be collected not an answer to the questions in the text, but an intimation, and that but an imperfect one, of the course to be taken for giving such an answer, and, at any rate, some idea of the difficulty as well as the necessity of the task. If it were thought necessary to recur to experience for proofs of this difficulty and this necessity, they need not be long wanting. Take, for instance, so many well-meant endeavours on the part of popular bodies, and so many well-meant recommendations in ingenious books, to restrain supreme representative assemblies from making laws in such and such cases, or to such and such an effect. Such laws, to answer the intended purpose, require a perfect mastery in the science of law considered in respect of its form, in the sort of anatomy spoken of in the preface to this work. But a perfect, or even a moderate insight into that science, would prevent their being couched in those loose and inadequate terms in which they may be observed so frequently to be conceived, as a perfect acquaintance with the dictates of utility on that head would, in many, if not in most of those instances, discounsel the attempt. Keep to the letter, and in attempting to prevent the making of bad laws, you will find them prohibiting the making of the most necessary laws, perhaps even of all laws. Quit the letter, and they express no more than if each man were to say, your laws shall become ipso facto void, as often as they contain anything which is not to my mind. Of such unhappy attempts, examples may be met with in the legislation of many nations, but in none more frequently than in that newly created nation, one of the most enlightened, if not the most enlightened, at this day on the globe. Take, for instance, the Declaration of Rights, enacted by the State of North Carolina in convention in or about the month of September 1788, and said to be copied, with a small exception, from one in like manner enacted by the State of Virginia. The following, to go no farther, is the first and fundamental article: that there are certain natural rights of which men, when they form a social compact, cannot deprive or divest their posterity, among which are the enjoyment of life and liberty, with the means of acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety. Not to dwell on the oversight of confining to posterity the benefit of the rights thus declared, what follows? That, as against those whom the protection thus meant to be afforded includes, every law or other order divesting a man of the enjoyment of life or liberty is void. Therefore this is the case, amongst others, with every coercive law. Therefore, as against the persons thus protected, every order, for example, to pay money on the score of taxation, or of debt from individual to individual or otherwise, is void, for the effect of it, if complied with, is to deprive and divest him, pro tanto, of the enjoyment of liberty, viz., the liberty of paying or not paying as he thinks proper, not to mention the species opposed to imprisonment, in the event of such a mode of coercions being resorted to; likewise of property, which is itself a means of acquiring, possessing, and protecting property, and of pursuing and obtaining happiness and safety. Therefore also, as against such persons, every order to attack an armed enemy in time of war is also void, for the necessary effect of such an order is to deprive some of them of the enjoyment of life. The above-mentioned consequences may suffice for examples, amongst an endless train of similar ones. Leaning on his elbow, in an attitude of profound and solemn meditation, "What a multitude of things there are!" exclaimed the dancing master Marcel, in a minuet. May we now add, and in a law. End of chapter 17. End of an Introduction to the Principles of Morals and Legislation by Jeremy Bentham.